Greetings and welcome to World Intellectual Property Day, hosted by the New Mexico Small Business Development Center, Technology Commercialization Accelerator, here at New Mexico Institute of Mining and Technology in Socorro, New Mexico. Bienvenidos. My name is Estefanita Rawlings. I'm the Center Director, Coordinator for the TCA. Welcome and thank you for attending the TCA World Intellectual Property Day celebration. World Intellectual Property Day was established in 2000 by the World Intellectual Property Office, WIPO, which consists of 193 member states around the world. World Intellectual Property Day encourages engagement among government, private industry, and the public on intellectual property promotion and protection. This year's theme is IP and SMEs, taking your ideas to market. Today we have presenters from the New Venture Division at New Mexico Tech, the Texas Regional United States Patent and Trademark Office, and special guest, Professor Lawrence Udell. The presenters will range from intellectual property basics, intellectual property abroad, cybersecurity, venture groups, and the presenters from the USPTO are or have been patent examiners. The lineup consists of Isama Mba, Paola Agudello, Hope Shimabuku, and Jeff Nickerson. Also presenting is Larry Udell, a new venture consultant for New Mexico Tech, presenting the big wide world of intellectual property. We have Peter Anselmo from New Mexico Tech, and we have David Irvin from New Mexico State Ptrc, which is Patent Trademark Resource Center. This program will last approximately 4 hours. We will be running the same Zoom call for the 4 hours, so one can pop in and out of the same Zoom link. Listed above here is the schedule. So this morning we will have myself and Dr. Anselmo with the welcome. We will have Isama and Paola with intellectual property basics. And then if we have, if our Q&A goes over, that's fine. We have a break. If not, the New Mexico Small Business Development Center will do a commercial break for us. And then we have intellectual property abroad by Hope Shimabuku. And then during the second break, we'll have David Irvin from the Patent and Trademark Resource Center. And then we'll have cybersecurity by Jeff Nickerson. And then the guest speaker, Professor Lawrence Udell. We have over 150 slides to go through today. So there's going to be a lot of information, but feel free to pop in and out we will go with the schedule. So the New Mexico Small Business TCA Center is happy to celebrate World Intellectual Property Day to promote intellectual property awareness to the businesses and people of New Mexico. We want to make the business owners, entrepreneurs, and inventors aware of the intellectual property and protection available to them. During these presentations, we will review the types of protection here in the United States, but also the protection available at the world level. And also because of the most recent cybersecurity breaches, we will have a presentation on cybersecurity. Now, I will provide a brief introduction to the New Mexico Small Business Development Center for those of you that don't know about us. Then we will have Dr. Peter Anselmo, Director of the New Ventures here at New Mexico, talk about his division and experience as the Executive Director of the Office of Innovation at New Mexico Tech. Then we will jump right into our scheduled presentations from our presenters from the USPTO. I'd like to give a special thanks to New Mexico Small Business Development Center, Adrian Gallegos, the Associate Director. Leslie Iverson will be joining us later, and Annalena Speck for helping with all the advertising and setup of this webinar. So in 2020, the New Mexico Institute of Mining and Technology teamed up with the New Mexico Small Business Development Center. Through a signed cooperative agreement, the Technology Commercialization Accelerator emerged to provide unique support to New Mexico entrepreneurs, thinkers, and inventors. Because of the COVID-19 pandemic, we have been an at-home office providing service to our clients via the telephone and Zoom meetings. We have set up a website on our server at New Mexico Tech. It's called management.nmt.edu/TCA. And like our New Mexico Small Business Development Center network, we provide no-cost counseling to clients throughout New Mexico, but the difference is we offer counseling regarding intellectual property. We started our special project during the pandemic, and with travel limits, I started searching the internet for resources regarding IP. I found so many resources online, so many webinars regarding intellectual property, and they were free webinars. Because I was like so many of us looking for information and not being able to travel, I decided I would have World Intellectual Property Day as a virtual event. So you as businesses, entrepreneurs, inventors could access information from the comfort of your home or office and not have to travel. As you will hear today, IP consists of patent, trademarks, copyrights, and trade secrets. We educate and expose our clients to intellectual property. We educate them on the process of registering intellectual property. One of the main ideas we try to emphasize is that we need to make sure the idea is novel, useful, and not protected by someone else, which would be infringing on someone else's idea. So I mixed up on my slide, sorry about that. Anyway, we serve the residents of the state of New Mexico. We provide counseling to clients throughout the state. Our clients are existing businesses looking to register their trademarks for goods, service, inventors, entrepreneurs, and looking to see if their ideas are protectable. We provide counseling services to clients during all stages of their idea. They may have an idea, they may be in the prototyping stage, testing their ideas. They may be looking to take their product to market. Our clients have applied for provisional patents, for patents. We have clients working on trademarks. Several of our clients have copyrighted books and presentations. We have some clients working with the New Mexico Small Business Assistance, testing their idea, and several have businesses in the process of marketing their products. We try to educate and empower them to learn as much as possible of what has been done to protect. We try to educate and empower them to learn as much as possible about what has to be done to protect intellectual property. In the past, we have partnered with the New Mexico Cybersecurity Center of Excellence Office to provide cybersecurity training for the New Mexico Small Business Network and New Mexico businesses. We offer trainings on Zoom security and what businesses should look for to protect client information. This past month, we partnered with the Patent Trademark Resource Center at New Mexico State, David Irvin, and we provided webinars on patent and trademark searching on the databases at the United States Patent and Trademark Office. We continue to provide no-cost counseling to our New Mexico residents to help them move forward with our ideas. As for our partnership with New Mexico Tech, besides office space, TCA subscribes to PatBase, which is a global database used to patent patent search in 128 countries, including the United States. We currently use the software to help our clients search globally for prior art and allows the Office of Innovation Commercialization and New Mexico Tech to help students with their patent searches. Because of our current pandemic, our office has been working remotely with plans in the future to house our office at New Mexico Tech and Socorro, New Mexico. And with that, I'd like to introduce Dr. Peter Anselmo, who is the Director of New Ventures at New Mexico Tech. And he has been with New Mexico Tech for 29 years. He's Director Head of the Management Department. And so I'd like to introduce Peter Anselmo, Dr. Peter Anselmo.
Steffi, Peter may be having some technical difficulties. So
Okay.
I am going to try and see if perhaps he can call in, but we may need to
Oh, did
to
you
have
do
him
it?
speak
Good,
a
but
little
I'm
bit later.
blocked from starting my video. Did you release that?
Yeah, he is released to do that. He might be having some issues with his internet. So I'm going to try and work with him, but we may just need to move on, and then I can let you know once he's up and running again. Is that going to be okay?
Yes, just give me 1 minute.
Okay. And Peter, I'm going to try and get you a number to call in from, if that helps.
Okay, it's working now, but
Oh, it's working
Oh,
now.
okay,
But I don't know if it's
Perfect.
going to stay working, right? That's the thing, but
it's
fine
okay.
now. So Steph, what am I supposed to say? I missed
Talk
what you
about
said.
your new ventures and what you've done with the Office of Innovation at New Mexico Tech.
Well, it's really what Larry and I have done at New
Okay.
Mexico Tech. But so from the perspective of a university, protecting intellectual property is vital because universities make their money from licensing, either to startups that the university has something to do with, which is the case in our Office of Innovation Commercialization, and also through our Director of New Ventures, which is now me, but also licensing to any interested company that's willing to make a reasonable deal. So if you're going to go that route, then some kind of patent protection is probably hard to avoid. But I think it's important to remember that patents are not the only solution. I mean, ultimately, the best solution if you want to protect your intellectual property is never tell anyone about it. And on the other end, if you want to tell everybody about it, you need to have an ironclad protection strategy. And that protection strategy can change over time. It might be different when you start out. And it should be something that you have in your mind, that an inventor or a company has in their mind as something that will be dynamic. And what I mean by that is, it's likely that there will always be new innovations coming along, new intellectual property, revisions of intellectual property that will need to be dealt with in the context of an overall plan. And also it's also likely that you're going to have to tell people about what you've got. So in addition to patents, or in lieu of patents, there are trade secrets that an inventor and a company can think about how to protect trade secrets. We recently are developing a company around a very novel, very compelling invention that will be ridiculously easy to steal. So our strategy for that is we have developed our person on campus who's in charge of non-disclosure agreements developed a trade secret agreement that has some teeth in it. And by teeth, I mean the person who signs that agreement understands that there's a clause in there that says, we will sue you if you reveal this, and we will go for maximum recovery. And we ask them to sign that. So you can say, well, that's great. So I don't need a patent. I just need a trade secret agreement. Well, so there's always going to be an issue, right? So the issue with the trade secret agreement is we don't want to have very many of them. Suppose we have 5 trade secret agreements out there. Only those 5 people, in addition to New Mexico Tech, know about the trade secret, and suppose the trade secret gets out. So we have a handful of entities that we can attempt to
Did you go?
Hi, Peter. I don't know how well you can hear us, but we're losing you. I did just, oh. Hi, Peter, can you hear us okay?
Yeah, I'm back.
All right. You just cut out for just one little second there. Go ahead, Steffi. I'll let you handle
Okay,
it.
all I was saying was my trade secret story, there's an example that trade secrets aren't the be all end all. Patents aren't the be all end all. People can steal patents. This particular
Okay. You cut out a bit.
disguise.
Peter, you're cutting out. Are you there?
Do it.
Okay.
Anyway, bottom line is
Okay, Peter, we'll just hold you off for a bit because you're not coming in.
I'm going to take the liberty of going ahead and muting Peter, and then I can have him call back in. I will talk to him and I'll keep you updated, Steffi. Sorry, everyone, about that, and thank you.
Okay. Okay, can everybody hear me? Sorry about that. So like Peter was saying, with intellectual property, people can steal your ideas, and you should protect them. And I think that's a big thing that we talk about, is protecting your ideas. I know when I work with my clients, if they have an idea and we've searched and we can't find anything, you need to contact a lawyer so you can have a provisional patent out there, because people will take your idea. So let me see where we're at. I think we still have about 10 more minutes before Isama and our intellectual property basics come on. So we are getting people in, and we did, for those of you, we did have a speaker, but we had some technical difficulties, and maybe he might come back in just a bit. I don't know if all of you, when you received the invite, oh wait, I'm going to stop sharing just for a minute. When you received the invite, you had a list of all our presenters. And so I'm going to go and talk about our presenters. So Larry Dell, who's our featured presenter, is a well-known as founder and chairman of the California Invention Center, created with federal funds in 1995 at California State University. He has taught courses on new ventures for over 40 years at universities throughout the United States and in foreign countries for WIPO, A member of the Licensing Executive Society since 1982, he founded the Silicon Valley chapter in 2000, which today is the #1 chapter in LESI, 97 countries. Founder of over 30 new ventures, Professor Udall provides consulting to both startups and Fortune 500 companies and lectures frequently at inventor, corporate, and government functions throughout the US. He is Vice President of American Innovators for Patent Reform, besides serving as Senior Consultant to General Patent Corporation. He also serves as a corporate officer and board member of companies, and his illustrious long career has mentioned hundreds of inventors and new ventures. He has worked with world-famous inventors, including Stephen Hawking, Bill Lear, Jim Ferguson. A few of his many accomplishments: provided consulting to the QVC television network on inventors, produced technology exhibitions attracting over 1 million attendees at the California State Fair, established a worldwide network of colleagues in various disciplines, created the first major invention exhibition in San Francisco in 1957, attracting 6,000. And then we have Isama Amba. He's a supervisory patent examiner at the United States Patent and Trademark Office at the Texas Regional Office in Dallas. Isama joined the United States Patent and Trademark Office in January of 1999 in the Technology Center and became a primary examiner in 2005. He served on a career development detail as a trainer at the Patent Training Academy and became an SPE in January 2017. We have Paola received her, Paola Agudello is a primary patent examiner and outreach coordinator. She received her BS in civil engineering from the City College of New York and worked as a structural engineer for a consulting engineering firm in New York City. Moved to Alexandria, Virginia to join the USPTO in 2011 and as a patent examiner in Art Unit 3633. She became a primary examiner in 2017 and moved to Austin, Texas that same year. She enjoys hiking and exploring the Texas trails. Also loves traveling with her husband and her kids, 14-year-old boy and 8-year-old girl. Hope Shimabuka, Director of the Texas Regional United States Patent and Trademark Office, will be presenting on Intellectual Abroad. As the Director of the Texas Regional United States Patent and Trademark Office, Hope carries out the strategic direction of the Undersecretary of Commerce for Intellectual Property and Director of the USPTO, and is responsible for leading the Texas Regional Office, focusing on the region and actively engaging with the community. Ms. Shimabuko ensures that the USPTO's initiatives and programs are tailored to the region's unique ecosystem of industries and stakeholders. And then we have Jeff Nickerson, who received his BS in computer engineering from the University of Maryland, Baltimore County in 2007. He joined the USPTO in June of 2007 and examined in the computer networks technology area. After becoming a primary examiner in June 2012, he served as a TC2400 trainer and search mentor. He became a supervisory patent examiner in October of 2013 and currently supervises an art unit in the cybersecurity area. He also has roles on the USPTO hiring and recruiting teams, on the Office of Innovation, Development, and Pro Se Assistance teams, as a PE2E ambassador, as a PTAB technical training liaison, and on the patents training team. Outside the PTO, Jeff has previously served as a private detective in Maryland and volunteered as a suicide hotline counselor in the DC metro area. He enjoys soccer, snowboarding, riding motorcycles, traveling and training dogs. So thank you for that. I had to fill in there. So we have a lot of PTO examiners, or they've been previous examiners. So please, when you, after our presentation, you can put your questions in the Q&A. We will have a Q&A section after the presenters present, and we'll go through all your questions as time allows. Does anybody have any Q&A for me? Still have 4 minutes. It looks like we have, our people are coming in. We have participants from all over. I see we have Glenn Walters is on. He's from the New Mexico Small Business. So hi, Glenn. Thank you for joining us. We have people from the network joining us, and then we also have clients in with us. So I do appreciate all you showing up, and I will get ready for Paola to and Isama to start with their presentation so they can see if they can share. Do you guys want to go ahead? And I will mute myself.
Thank you, Steffi. I'm going to try to start sharing now.
Thank you very much.
So I'm ready whenever you think that we should start.
I know we're 2 minutes ahead, but I'm going to go ahead and let you start.
All right, so we are starting. So good morning, good afternoon, everyone. My name is Paola Agudello. I am a not supervisor. I am a primary patent examiner. I have been a patent examiner for more than 10 years. I examine in the area of construction materials, construction methods. I look at tiles, patent applications for tiles, floorboards, windows. I look at methods of insulating a wall, method of insulating a window, anything related to construction. And I'm here from the patent office with my colleague, Isama Omba, and both of us are going to be presenting to you the topic of like a brief introduction to intellectual property. So with that being said, before we get into it, I'm going to go over a very brief overview of the patent office. So last year, the fiscal year 2020, the patent office had almost 13,000 employees, the majority of them being patent examiners. There is also a good number of examining attorneys in the trademark area, and we have both a patent and trademark trial and appeal board teams. In terms of patents, there were almost 400,000 patents issued in the year 2020, and we had more than 650,000 applications filed. And similarly, in trademarks, we were pretty busy as well, with almost 300,000 certificates of registration issued and more than 700,000 trademark applications filed. So regardless of the interesting year that 2020 was, the PTO stayed pretty busy, and inventorship also stayed pretty active. And down below here in my slide, there is a picture of the headquarters of the patent office in Alexandria, Virginia. That is about 30 minutes from Washington, D.C., and it's a beautiful campus. There's even an inventors museum. So you're welcome to come visit, because I'm not there. All right, so let me tell you a little bit. In the year 2011, President Obama signed the America Invents Act law, which is also known as the AIA law. This law, among other things, allowed the PTO to establish what we call satellite offices. And there are 5 satellite offices. The first one opened in Detroit in 2012 and covers the Midwest region. So as you see here in the map, each regional office covers and serves specific states. For instance, the Texas office covers the area of New Mexico, Texas, Oklahoma, Arkansas, Louisiana, Tennessee, Mississippi, and Alabama. And that takes us to the Texas regional office. Our office is located in Dallas, and one of the main goals of our office is outreach. What is outreach? Is to connect with stakeholders, with inventors, with small business, pretty much to serve the public. So please know that we would love to hear from you. We're here to answer your questions, to guide you through your process, and you are more than welcome to contact us. Later in this presentation, I'll give you specific phone numbers and email addresses to contact us. All right, so with that being said, we're ready to start talking about intellectual property. As you may know already, intellectual property is usually referred to as IP, and that's how we may be referring to it in this presentation. All right, so what is intellectual property? Just like any type of property, intellectual property is something that you own. And when you own something, you can sell it, you can buy it, obviously, and you can even lease it. So similarly, like when you own a property, when you own a house or a piece of land, you always want to make sure to mark the limits, to really put a fence around it, pretty much, right? You put a fence and you know that what's inside is your property and what's outside of the fence is obviously not. So in the same way, you want to do that with intellectual property. And for instance, in a patent application or when you own a patent, the fence of your patent is called the metes and bounds. So you define the metes and bounds of your invention. What exactly is it that you are getting protection on with the metes and bounds, and that's done through the claims. The claims in a patent is the legal portion of your patent, or which is a document, and that's what defines the metes and bounds of your invention. So intellectual property, there are 4 different types of intellectual property. And hopefully by the end of this presentation, after Esama and I talked about this, you will have a better understanding of at least the difference between these 4 and what do they apply to. So we have patents, trademarks, copyrights, and trade secrets. And what a better example to illustrate this than with a phone, a cell phone. A cell phone is actually a device that includes all types of intellectual property. So we have, there are trademarks in a cell phone, in the name, in the brand, the name of the phone. Those are trademarks that identify the company that makes it. There are design patents. A design patent protects the external appearance or the design of something. So for instance, the home button, just that little shape of it, it has a design patent and is protected. There are copyrights in the software code, the instruction manual, even the ringtone is copyrighted. And definitely there are utility patents. There can be hundreds of patents within one cell phone. There's a patent for a camera, a patent for the battery, the screen, et cetera, et cetera. Each component, it can have a patent. And speaking of patents, I'm gonna pass it on to my colleague, Esama. He's going to go in depth discussing patents.
Thank you, Paola. If we could move to the first slide, please. All right, so what is a patent, right? We talk about patents, right? As Paola said, right, a patent is a property right? So it's a right that is given to an inventor, and the right that is given to an inventor is, to exclude others than the inventor himself or herself from making, using, offering for sale, or selling or importing the invention in the United States. So that's the right that is given to an inventor, with the patent. So the patent gives you that right that exclude other for using your idea or your invention without your permission, right? And this does not grant you the right to, to make use or offer for sale your invention, right? It's just a right that, other excluded. It's your invention, it's your property. So it's, whatever you want to make with it. Next slide, please. So there are three types of patents, right? Utility patents, as we heard, design patents, and then planned patents, right? The one that most people are probably familiar with is the utility patent, right? So this is the one where, as Paola was explaining earlier, it's a whole disclosure of the invention. It has how it works. It has claims. It has drawings, and it has what is it? Specification. There's specification. There are drawings. There are all the components of that makes that invention. So it protects how the invention works or function, and it's valid for 20 years from the filing date of your invention. So it could be a process, how to do something, or how a machine works. It could be a machine. It could be an article of manufacture or composition of matter. So all these are type of patents that you can apply for, right? And now design patents, as we also saw, they protect how a product looks or how something looks or the aesthetic look of the product. And then planned patents will be, to protect newly strained of actually producing flowering plant fruit trees and other hybrid plants, for also 20 years. Now the design patents, are valid for 15 years from the date that the patent is granted. Next slide, please. So this is an example of a design patent. It's a video game console, right? And you have examples of what was granted designs of these game console here. We are familiar with different those game console like Xboxes or the PS Station console. So all those are how those products look, because when you get it, once you get that, just by looking at it, you can already tell, what product, you have. Next slide, please. And then we have plant patents, like we talked about. So, this is a hybrid plants, that are made, by mixing, different plant and, to come up with a new type of plant. Next slide, please. All right, so how do I get a patent, right? So you get this new idea that you come up with that, an idea that nobody else, that you think nobody else has, right? And you do your work, and you search, and you quite don't come up with something else that you think it's out there that is close to what you have. Then the path to a patent, right? You can file a provisional application. This is optional, and then you move to the non-provisional, which many people are familiar with, and then it goes to an examining process, and then eventually it issues as a patent, right? The provisional application is good because the United States now is first to file. We're under the First to File Act, right? So it goes with the effective filing date of the application. So provisional application is not a complete application per se, but what you want to do is the provisional application, you want to make sure that you put as much information in there as you have of your invention at the time that you're filing this provisional application, because this is your date, right? This is the date that you can go back to. And if somebody files a similar application, with a date that is supposed to your date, the provisional application date. So when these cases get, tried, we have to go back and see who filed first. So that's why it's good to file a provisional application. Even if you don't have a complete idea yet, you can go ahead and file a provisional application, and you will get protection for that part of disclosure that is part of the provisional application. So it doesn't have to have a complete application. It can just be drawings, or just claims, or just part of the specification, and you will get protection for that disclosure at that point. And you have 1 year to file the non-provisional application, which is the complete application that will be examined and eventually issue, as a patent. So this is a trivia question for all of you. Can you name the only president that hold a patent? If you could move to the next slide, please. Oops, I think we did we skip a slide? Well, I mean, the only president that holds a patent is Abraham Lincoln. I don't remember the date off my head. Maybe I can find it for you. I thought it was part of. But anyway, yes. So President Lincoln, right, received a patent in May 22, 1849, for a device to lift boats over shores, an invention that was actually never manufactured, but it made him the only president to actually hold a patent. So if you move into trademarks, next slide, please. So what is a trademark? So it's a word or a phrase or a symbol. It could be a design or a combination of words, phrases, symbols of design that distinguish the source of one good, right? I think we are familiar with the McDonald's arch, with the Coca-Cola design, and the way with the black Coca-Cola name, and then with the red mark under the line, or so those are examples of trademark. Or service mark is also the same, and except that it identifies or distinguishes the source of the service rather than the product itself. Next slide, please. So these are examples of trademarks, right? The Nike swoosh, the Starbucks logo there, the Target, sign. And next slide, please. See, these are all the examples of trademarks. It could be a smell, colors, sounds, shapes, packaging. I did not, most of those things, I was surprised, to know that you can trademark a smell. These are very interesting thing here, or the famous Simpson, do expression. Those are all, type of things that could be trademark. Next slide, please. I think I'll give back to Paola to continue with the rest of the examples of trademarks. I mean, not trademark, but IP protections. Sorry.
Thank you, Sama. Thank you. Okay, so the next type of intellectual property that we're going to discuss is copyrights. So what are copyrights? Copyright is a legal protection provided to you by the laws of the United States, and it's given to authors of original works. So copyright is a bundle of rights that gives the owner the right to make copies, to modify the work, distribute the copies, and perform or display the work publicly. So to get copyright on something, the work has to be creative. But the bar on what creativity really is pretty low. In fact, the Supreme Court has held that, quote unquote, the requisite level of creativity is extremely low. Even a slight amount will suffice. So like who's who to tell you that your work was not creative? If you think it's creative, most likely it qualifies. An example of something that is not creative, that does not qualify for copyrights, is the white pages section of a phone book. Those are definitely not creative and they're not copyrightable. So what can be protected under copyrights? The most common items are books, sculptures, movies, and songs. Copyright duration is the life of the author plus 70 years. And that's why musical compositions from all masters like Beethoven or Mozart, they are now in the public domain and we can all freely use them. Other things that can be copyrighted are logos, product design and packaging, advertising materials, instruction manuals, educational materials, software code, and website content. However, there is some crossover here between some different types of IP. For instance, a logo can be copyrighted and serve as a trademark. And so you're mixing both copyrights and trademarks there. Also, methods which are patented, methods, for instance, for processing software, those are protected by patents, but they can be also, the actual code is copyrighted. And that's it for copyrights. Now let's talk about trademarks. Trade secrets, sorry. So trade secrets consist of information. It can be a formula, a recipe, a program, a method, or a technique. To meet the most common definition of a trade secret, the information must be used in business and give an opportunity to obtain an economic advantage over a competitor that doesn't know it. So you have to prove that you will get an economical advantage if you have the trade secret. So to better understand what trade secrets are, it's easier to compare them with patents. So obtaining a patent involves a quid pro quo. You get exclusive rights to make, sell, or use your invention for 20 years. Trade secrets, obviously, the trade secret remains secret until you decide to disclose it. In a patent, you actually have to disclose how to make, how to use, and how it works, everything about your invention. And you do that in your patent application. And that's the quid pro quo. You know, you're getting the rights, you own the rights to do all these things. And in exchange, you have to tell us how it works, because you're going to have this for 20 years. And someone actually can modify or actually improve your invention, and they can apply for a patent. Similarly, in trade secrets, someone can reverse engineer your invention, your secret, and that's actually okay. It would not be considered misappropriation. And actually, the Supreme Court has ruled that reverse engineering is considered fair and honest means. So these are some notoriously well-known trade secrets in the world. The most famous one, also that Osama was talking about, the Coca-Cola recipe, is probably the best kept secret in the world. There is the recipe for KFC. KFC is known to include 11 herbs and spices, and even the head chef of KFC has claimed that he doesn't know specifically what these are. The Krispy Kreme donuts, the founder of Krispy Kreme in 1937, Vernon Rudolph, bought the recipe for this secret recipe from a French chef in New Orleans, and it's been kept secret since then. And we have PageRank, which is the algorithm used by Google to rank its web pages in their search results. So the method of applying the algorithm is subjected to patent protection. However, the manipulation of the algorithm by link farms and other tools, it is closely held as a secret, as a trade secret. Okay, so that is all we had to say about the 4 different types of intellectual property. In this chart here, we're trying to compare all the types of intellectual property. In patents, as Amma mentioned, there are 2 types of patents, utility and design patents. And the difference between them, well, the utility patent is given for 20 years and the design patent is for 15 years. The trade secret might remain secret until you decide that it's no longer a secret. Copyrights, as I mentioned, is the life of the author plus 70 years. And the trademarks are valid until you abandon or don't use them anymore. And as usual, the requirement to obtaining a patent is that it has to be new, novel, or non-obvious. In trade secrets, it has to have commercial value. To obtain a copyright, it has to be a tangible medium and it has to be original. And for trademarks, you have to actually show that it can be used in commerce. So, and there are other characteristics here that obviously you can all read. You will get a copy of this presentation so you can have this for your records. And with that, I am going to show you some of the resources that we have at the PTO. And I need to warn you, they are a lot. So I'm not going to bore you giving you phone numbers and website addresses or anything. So I'm just going to try to show you what we have, what is out there. And as I mentioned, you will have a copy of this so you can use whatever applies to you. So the main way to start looking for help is if you go to the USPTO main website and in the search box you type Texas, that will take you to our Texas regional office. And from there, I mean, the possibilities are endless. You can start by sending us a quick email asking for specific help, and we will definitely guide you in the right direction. There are also on the same main website, there are startup resources. There is a ton of information here. Again, look at it and use what applies to you. There is a scam prevention resources. There is pro bono resources for pro se inventors. Pro se inventors are an inventor that doesn't have an attorney that represents them. And like I said, a lot of other resources. And there, if you go the trademark way, there is a trademark assistance center. Here is the phone number and the email address. And this is experts that are here with the only purpose of providing guidance. So please don't hesitate contacting them. And if you decide to go on the patent way, then there is the Inventors Assistance Center as well. The same way, they're here to help you. One thing to note is, however, as much as all these people can help you, they will never, and they are not able to give you legal advice, and they are not able to tell you if your invention is patentable. That is the job of the patent examiner. So please don't call asking if your invention is new and if you're going to get a patent or no. They won't be able to tell you that. They will be able to tell you how to apply, how to check the status, etc. You can create like a little portfolio of your intellectual property, and you can manage it all at myuspto.gov. That's where you create an account and you can keep track of all your applications. For trademarks, there's actually an app to track the status of your application. And the IP awareness assessment tool also, I believe we are running a little behind time, so I'm going to speed up. Like I said, we are all getting a copy of this. Please make sure you check your status and see if you qualify for the pro bono program. The pro bono program is done by areas. So the area that applies to New Mexico is the ProboPat. That's the agency that does it. Just Google ProboPat and you'll find all the information that's pertinent to New Mexico. There's also law school clinics. This is interesting for law school students, it's a great way to gain some experience and work with experienced attorneys at the PTO. Again, there are the Ptrcs. These are librarians that are also just waiting for you to contact them. They are experts in patent matters and IP matters, and they are happy to help you as well. If you apply for a patent application and you want it to be expedited, there is this program with a fee. You can get your examination expedited. You can request interviews with the examiner. If you have any issues with your examiner, you are encouraged to contact the patent ombudsman. And again, check your status. If you are a microentity status, you are you can get discounted fees. And that concludes our USPTO presentation. I think we have a few minutes to take questions if there are any.
Hi, everybody. It's Leslie with New Mexico Small Business Development Center. Great presentation. We do have a couple questions that have come in. Is it okay if I ask you a couple questions that have come in?
Yes, Esama and I are here to answer, and also our director, Hope Shimabuko, is here if there are questions that are out of our knowledge, which there probably are, so I'm sure she'll be happy to help us.
Okay, one of the questions that has come in is, what does it mean to defend a patent?
Do you want me to take that?
Yes, Hope, please.
All right. So what that means is that once you receive patent rights, it is for you to use as an offensive weapon or as a defensive weapon, just depending on what your IP strategy is, right? So one is that once you get a patent, it is yours for you to go out to stop others from infringing your patent. People don't automatically come to you. Usually, they don't usually come to you to ask for a license. So you need to make sure that you are out there watching to see if someone could potentially be using your patent. So when you do go into litigation or you are suing someone from infringing your patent, you need to defend your patent in court and your invention, and to say that, hey, I have rights to this, and then someone else is now infringing my rights. And so I am using my patent to say that you either need to take a license from me, or you need to stop developing or selling or whatever activity that they are doing that's infringing your particular patent.
Thank you, Hope. We have another question that's come in. This one, I believe you answered, but I was going to go ahead and read it. So anybody that did not have a chance to get the answer would be able to hear what you have to talk about on this one. Is the existence of a state trademark taken into consideration when a federal trademark is reviewed? If you could just reiterate your answer on that so we can make sure everyone has that.
Of course. So when we are evaluating trademarks, we are only evaluating trademarks that are registered with the United States Patent Trademark Office, so our office. So you can file a trademark with state agencies or within different states around the country, but we are not looking in those databases when we are making a determination on whether you have federal trademark rights or the right to be able to register within our office.
Thank you. Here's another question that's come in. What is a micro entity and how much of a discount do they get?
Paola, Osama, do one of you want to take that?
Yes, I'm getting that one because there was a slide about that. Microentity, there is a criteria if you qualify, and let me, if it's okay, I'll share the screen again. The discount is 75% of the fee, 75% off of the fees. And so these are the fees, and these are the main criteria for qualifying as a microentity. You okay, this is actually not specifically the criteria to be a microentity, but there is definitely a criteria that I don't know it right now, but I'll be happy to send it to you separately, and you can distribute it with people unless Hope knows what's the main criteria.
Yeah, let me go ahead and mention it real quick. So as a microentity, what that is that you're essentially a small business, and that's defined by the SBA as anyone who has 500 or fewer employees, and you also do not have more than 5 patents in which you are listed as an inventor on it. So that is what qualifies you as a microentity. And in order to obtain the right, what you need to do when you are actually filing your patent application, you have to fill out a form that pretty much attests to the fact that you say that I am a microentity. I qualify under all the criteria that you see that it says that I certify the following. And so if you certify against the following, then you qualify as a microentity, and that's all you have to do. And so that's where we pretty much take your word for it, as long as you swear to it and that you certify.
We may have lost hope. Would anyone like to continue, or shall I go on to one of the other questions?
I think the answer was already given pretty much.
Thank you.
Yeah, thank you.
Okay, hopefully we'll get Hope back up and running. Here it's kind of windy, so she may have some technical difficulties. I've heard of the Texas Regional Office, but I always thought it just served Texas. Does it just serve Texas, or has it been considered to rename it something more inclusive, like the Southern U.S. Regional Office?
Yeah, unfortunately, that is definitely a question for Hope. She's the director of the Texas office, but so I'm not aware of any propositions to change the name or any initiatives to do so. However, yes, I would like to reiterate that we do serve New Mexico, Oklahoma, Arkansas, Mississippi, Alabama, Tennessee, and Louisiana, in addition to Texas. So when they say Texas Regional Office, we are referring to all those states.
Thank you. And I think Hope is trying to reconnect. So let me make her a co-host. Maybe that'll help. Okay, that is all the questions. This is going to be, hi Hope, I see you're back with us.
Sorry.
Hi.
I am connected to my personal phone now, so apologies. Give me a second.
Okay. So we're going to wait for Hope. And if you guys have any last comments or wrap up before we finish your segment, that would be great. If we can hear from your team. Steffi?
I have a question. So on the trademarks, when you say you can call, how much information can you help? Like you said, with the patents, you can't say if they're patentable or not, but how much help do you give with the trademarks?
They will definitely give you guidance on where and how to search for the trademarks. Similarly to patents, if you call and you ask for help on search, they will guide you where to go or what are the the search engines that we use, and they will also let you know about trainings about searching. So it's the same for trademarks or patents. You will get assistance on searching. I don't think they can search for you.
Thank you. Yes, that was good.
Steffi, do you have any other questions?
No, do we have any other questions from the participants?
We are good on the questions. Do we have any last comments before we break?
No, our presentation is
Well,
done, and thank you so
yeah,
much for having us. Sama, do you have
maybe
anything?
no. Yeah, before we maybe Hope can answer that question about the come back to that question about why the regional office was named the Texas regional office and not the Southern. So if you can ask that question again, maybe Hope may be able to give more light to it.
Be glad to. We had a question that came in. I've heard of the Texas Regional Office, but I always thought it just served Texas. Has it been considered to rename it something more inclusive, like the Southern U.S. Regional Office?
So that is a really good question. And it's actually a question that we've been debating for a couple of years right now. When the Texas Regional Office was originally set up, that actually was an expansion of the original name that they were really thinking of. They were originally going to make it more regional, but just to Texas, saying that it was the Dallas Regional Office or the North Texas Regional Office. And so eventually they settled on the Texas Regional Office. As we are looking across the region, because clearly, as New Mexico knows, we are not only servicing the Texas area, we service Texas, the surrounding states, and other states as well. And so there is a question on whether we should be expanding beyond it. I don't have an answer right now. It is something that we are talking about. And so the change may come, but it may not come immediately. And so we'll have to actually really figure out what it's going to be at the end of the day.
Thank you, Hope. We have no open questions right now. If we do not have any more questions, we're going to go ahead and take a break. We will get back on at 12:30 Mountain Central Time, which would be 1:30 Central Time. And if we have anyone in the Pacific time zone, that will be 11:30. I'll pop on a little bit early and update everyone on SBDC and some of our upcoming webinars. If you'd like to take a break for just a little bit, we'll be back on in just a couple minutes. Thank you.
Hi, Anne. Do you want to test this real quick?
This is Steffi. Who's testing?
Hi, Steffi. This is Hope. I was trying to test because I think I'm logged in twice. And so we were trying to figure out which one to kick off.
Yeah, sorry about that. Hope,
Okay.
I'm gonna go ahead and remove what I think is the phone line. Is that what we were hoping to do?
I think so.
Okay, let me go ahead and do that and see what happens real quick.
Okay.
All right, it looks like you're still here, so it seems like we resolved the issue.
Okay, perfect.
Awesome, thank you.
Thank you.
And I'm going to, hi, everybody. It's Leslie with the New Mexico Small Business Development Center webinars again. We're coming up on getting close to 12:30, and I thought I would update everyone on some of our upcoming webinars that we have going on right before everyone pops back on or finishes their iced tea or coffee or something like that. But we're excited that Steffi has put this on today. This is great information. We also have coming up top power words to use. I want to remind everyone that our webinars are always no cost, and we do offer no cost confidential counseling. So if you would like to learn more information on getting Small Business Development Center counseling, our website is nmsbdc.org. Also coming up, we have small business website 10 mistakes you must not make. I think that's going to be a very interesting one. We have a bilingual session coming up, which is going to be mental health and COVID, how your businesses and how you personally can take advantage of a bilingual session on mental health and COVID. Also coming up, moving your business to New Mexico. That's going to be another information-packed webinar on how to move your business to New Mexico. Spying on the competition, sneaky but legal. Basic steps to starting a business in New Mexico, always a popular topic to get an overview on how to do that. We have essential elements that should be in every employee file. That'll be coming up May 6th. I have a couple minutes, so I can tell you a couple more before we get started. A retailer's secret to succeeding online. We have maintaining personal privacy and cut your costs by moving to the cloud. Again, all great webinars coming up, and we do offer those at no cost. I wanted to let everyone know we'll be starting in just a couple minutes with intellectual property abroad.
This is Steffi, and I just want to let you know that the Intellectual Property Abroad by Hope Shimabuku will be starting shortly. I want to apologize for these long breaks. I was hoping to get more questions and keep our speakers busy. So if you have questions for Hope, again, put them in the Q&A. Again, thank you for attending.
Oh. Okay, Hope, it's Leslie. I'll be running your slides for you. Just let me know when you'd like me to switch slides. And with that, if you'd like to introduce yourself, and it's time to learn all about it.
All right, thank you, Leslie. And my name is Hope Shimabuku, and I am the Regional Director for the Texas Regional Office. I have been with the USPTO for a little bit over 5 years. And prior to this, I was an intellectual property attorney for 2 Fortune 500 companies. And then I also practiced as an IP attorney for several law firms before going in-house. So thank you for joining us today. And I am actually going to be talking about protecting your IP internationally. So if you wouldn't mind flipping actually 2 slides over. So thank you. So one of the things and the concepts about intellectual property generally, not only with patents and trademarks, but also copyrights and trade secrets, is that it is territorial. There is no such thing as a worldwide patent, a worldwide trademark, a worldwide copyright, or a worldwide trade secret that is filed by any entity that will cover every country. So each of these individual intellectual property rights have to be secured individually, country by country. And so that's what it really means when I'm talking about territoriality. So what I'm going to do is I'm going to actually go through each one of the top 3 IP buckets, meaning patents, trademarks, and copyrights. Trade secrets, because it is a secret, you never really register it with any of the countries, including the United States. It is meant to be secret. And when you register something with, for example, the United States government, it automatically becomes public. And so there is no registration means for trade secrets. As long as you can keep it a secret, that's what you want to do. So I'm going to move into first the international framework. And if you wouldn't mind flipping over a couple of slides. So a lot of our agreements that we have and the different ways that allow us to be able to secure intellectual property rights with other countries are governed by treaties and other trade-related aspects. And so each of those are different agreements, and each one of the different IP buckets have a different agreement governing it. There is an overarching agreement, which is called the TRIPS agreement, the trade-related aspects of intellectual property rights. And what it does is it sets down the minimum standards that each of the governments have to have in order to grant intellectual property rights in particular nations. And so this is an agreement that actually is fairly new, and it was probably signed within the last 10 years. But this agreement allows you to be able to, or it sets the basic framework for all the other agreements and all the other treaties that govern the intellectual property rights. And so, for example, it sets up the basis for patent rights and what needs to be provided if you have patent protection for inventions. So, for example, governments can refuse to grant patents for only 3 reasons, and they have to be related to public health. And so one is that a government can, if they want to, choose to refuse inventions whose commercial exploitations needs to be prevented to protect human, animal, or plant life or health, for diagnostic, therapeutic, and surgical methods for treating humans or animals, or certain plant and animal inventions. And each of the countries have a right to determine how or at what point they want to deny those rights. But the TRIPS framework actually sets that up. So it allows them to be able to do that. And unless they fall into one of those realms, then they otherwise should not be refusing a patent in their particular country. Okay, so let's move on to the next slide. And I'm going to first touch on patents. And so there are a couple of different ways that you can actually secure patent rights internationally. And so if we could slide to the next slide, excuse me, and to look at this. The most common way, and I'll talk more about this, is called the PCT, the Patent Cooperative Treaty. And so that is the treaty that we actually have secured or we negotiated with several of our sister patent organizations around the world. And so, as I mentioned before, there is no such thing as a worldwide patent. There's a mechanism for you to more easily secure the patent rights through a single database system, which is what I'm going to be talking about, but there is no worldwide patent. Each of the different territories or the different countries, and in some cases, for example, the European Union, you can secure patent rights across the entire participating countries in the EU, or you can secure individual patents within each of the individual countries. But each one of them have different requirements and restrictions. Some of them allow for different requirements on novelty. Some of them have different requirements for industrial applications and different disclosure requirements, or even restrictions across the board. And so the United States has similar requirements as the rest of the world, but they may not be exactly the same country to country. So let's move on to the next slide, please. So the Patent Cooperative Treaty is a way for you to file a single application that can then subsequently be submitted to another foreign country for their application process. Now, you can go through the PCT, as they call it, or you can file individually within each one of the countries individually. Sometimes there's an advantage to go through PCT, as well as I'm going to talk about the Madrid Protocol later on. And it just really depends on how many countries you end up actually filing in. Usually, especially with patents, you need to, the break-even point is filing about 4 or 5 applications. And so if you're going to file about 4 to 5 applications, 4 to 5 different countries, then that's really the break-even point on whether you're actually going to be using the PCT or individually filing within that particular country. And so with the PCT, you can file one single application, and then you can go national, as I call it, or choose up to 153 other countries to file your particular application in. And what's the advantage of that? As I mentioned, 4 to 5 countries is probably the break-even point in order to file using the PCT. And so what it does is that if you file through the PCT, you can delay expenses associated with translations, foreign filings, and local associates. So what does that mean? When you file within the United States, you file in English. But when you file in another country, you need to file a translation of your English patent application in that particular country. And so sometimes you want to wait and delay that particular application and until you find out whether A, your application or your invention is really even profitable, or you want to get some additional seed funding or something else associated with it before you incur expenses internationally. So by doing a PCT, this allows you to do that because it allows you to delay some of those upfront costs that you may have to have if you file directly with that particular country. So let's move to the next slide, please. So what does this really mean? Okay, so the PCT is the Patent Cooperation Treaty, which pretty much acts as a patent application filing system. It doesn't let you actually file or prosecute the application within each of the countries until you go national. So going national means that you have chosen that particular country, and now you are submitting that application, that single application, and you are submitting it to that particular country for review. And then in that review, each of the individual countries will actually review that for their individual laws for patents to see if you actually get the patent right or not. So if we go to the next slide, please. This is where there are two different types of treaties that exist. The PCT, which is what I actually just mentioned, in which it allows you to go in and file one application, and then you can choose the countries that you want to go in, and then you can file it abroad. You can also file it through another treaty called the Paris Treaty, and that you can actually file a particular application as well. It allows you a certain delay, not quite the same delay as the PCT, but it gives you a 12-month grace period for you to also be able to file with a number of different countries. And the third way to be able to do this, the last way that's not listed in here, is you just file directly with the actual country themselves. And you could just go to them, submit all your paperwork, and file for those particular countries that you have. Okay. So let's move to the next slide and let's talk about another type of application. So for the applications that I just talked about, the applications are related to what we call the utility patents. And so those are the applications that you primarily think about. But if you remember, for those of you who were actually on the call for the earlier session, there's another group called design patents. And those design patents govern and protect the ornamental features of a particular design patent. And so around the world, they call that industrial designs. And the treaty that governs the industrial designs is called the Hague Agreement. So if we go into the next slide, please. So what exactly is the Hague system? It is, like the PCT that we just mentioned, it is a single international registration system. And so it allows you to also designate one or more countries. And in this particular case, there are 74 countries that participate in the Hague system to protect the design or the ornamental features of the particular application or the invention, that you are submitting in your application. And so, like all the other systems, the Hague system, it is not a reviewing system in which there is one international location for you to review. What happens is it is a review system that is based on a treaty, and then each of the contracting parties will actually review the application after you submit it in through the Hague system. All right. So, so if we go to the next slide. So what that really means is that the Hague system, it's primarily a procedural treaty, as I mentioned. It does not determine the conditions for protection or the rights that result from it All of those are governed by each of the countries that are participating in this particular system. All right, moving on to the next slide, please. So for trademarks, the overarching agreement worldwide is the Madrid Protocol. What you'll notice with the Madrid Protocol, which I'll go through in a minute, is it's very similar to the PCT. It is just on the trademark side. So if we go into the next slide, please, some of the things that you want to consider as you are looking at going national or going abroad with your particular trademark is where and what are you going to be doing with that mark? So for example, what goods and services are going to be marketed in that particular country? Are you going to be manufacturing that, or are you just going to be putting R&D facilities there? Are you planning on shipping those particular products or services outside of the country? How likely is it that it will be counterfeited? Because there are some countries that are more well known for counterfeiting products. And then how do you think in the future you're going to be expanding your business? So each of those questions need to be asked ahead of time in order for you to determine which country you want to actually apply for a trademark. You may not necessarily want to protect your trademark in every one of your goods and services in every single one of your countries. You may just want to be selective and determine certain countries and certain protection, certain goods, certain services, and different things like that with that particular country as you're trying to determine the strategy for filing your trademark. So next slide, please. So I am actually going to go through a hypothetical, all right? So let's say you want to file the mark T-Margate trinkets, and you want to file it as a good under jewelry class 14 in the United States, okay? But you also want to protect it in other countries. So if you go to the next slide, please. So in the United States, you file it with our office. You have the option to be able to file a use or intend to use trademark, depending on which one, whether you want to reserve your mark or you're actually using it. And then you can get a federal trademark through the USPTO. Now, if you go to the next slide, please. So now you want to actually consider possibly filing internationally. And so you want to look at the Madrid Protocol. And so, as I mentioned before, the Madrid Protocol is very similar to the PCT in the sense that it is an international filing system. It is not an international review system, and it is not a way for you to get a single international patent because there is not a worldwide trademark, a worldwide trademark registration that you could get. But what it is that you can file a single application into the Madrid Protocol. You pay one set of fees, so you only use one set of currency in this particular case. And then each of those countries that you select, they will individually review that particular application. Now, the reason that I had brought up the original application is that there will always be a home country that you file with. So for example, in this particular hypothetical, if you file within the USPTO, the United States, is going to be your home country, and that's the application that will be sent in through the Madrid Protocol. So let's go to the next slide, please. So when you go into the Madrid Protocol, or if you're looking at the Madrid system at a glance, there's two ways, just like in the patent system, for you to actually submit your application. You can actually submit your application directly individually to each of the different countries and have them review it individually. Or you can submit it through the Madrid system using your home application, and it'll be submitted through the International Bureau. And then through the International Bureau, then it'll be distributed to the countries that you actually select. So let's go to the next slide, please. So what does the International Bureau actually do? What they do is they actually review for formalities. They make sure that you've paid the right fee, that you have the correct publications or the documentation or different things that are supposed to be submitted with your application. And they also provide a notification to the countries that you have designated that you want to go into. And so the International Bureau then sends your application into your designated countries for them to do a substantive review, either refuse or accept your particular application for registration. So next slide, please. So what's the difference between the national and the Madrid, and what are the advantages besides it being easier for you to actually file? As I mentioned, for the national route, which is you filing individually with every country, you have to file with each and every office within that country. The international route, you don't need to do that. You have one office for filing. You only have one language. Understand that this is slightly different than the PCT, right? So for the Madrid, you have one language. You have one currency that you have to you can pay with. And then if you need to do any renewals or modifications, you could do one renewal and one modification through the Madrid. You're actually limited a little bit by going through the Madrid in the amount of changes that you can actually make. The other thing is that you don't need to have a foreign attorney or agent, meaning a local attorney or agent to represent you through the international route. But if you do have it and your application is refused, you still do actually need to have a local attorney or agent to be able to respond to that particular trademark office action that they send you. Okay, moving on to the next slide, please. So going back to our original hypothetical in which you filed an application, you received a mark in the United States. So going on to the next slide, please. And once you get your registration within the USPTO, you can use the circle R, okay? So going on to the next slide, please. If you decide to use the Madrid Protocol, then what happens is that your application from the USPTO then and your registration gets sent to the International Bureau. And then on the next slide, please, then the International Bureau will send it to all the individual countries for them to review. And in this particular case, Canada did not accept the registration, but Mexico and Jamaica did. So you are now registered in both Mexico and Jamaica. So, all right. So next slide, please. So that pretty much wraps up the trademark section. The last treaty that I am going to be talking about is on copyrights. And so let's move to the next slide, please. So WIPO governs a lot of what they call internet treaties, right? So what are your copyrights associated with the different things that you post on the internet, your different performances and different things for music and things like that are actually governed by a different part of the treaty called the WPPT, which is the WIPO Performance and Phonographs Treaty. But all of that is included, and this was updated recently just because of the internet age that we are currently in. The copyrights and the related international rights that are associated with copyrights are governed by what's called the Berne Convention. And so the Berne Convention is actually what you would be filing under, similar to what you would file under patents and trademarks. This is the actual treaty that you'll be looking at if you want to protect your rights internationally with copyrights, okay? So next slide, please. Now I'm going to spend a couple of minutes and then we'll open it up to questions after this. And I'm going to talk a little bit about what kind of resources internationally that the USPTO actually provides for those who do want to do some filings or protections overseas. And so the USPTO actually has an office called the Office of Policy and International Affairs, OPIA as the acronym. And so that particular group, the purpose of that group is to develop and promote high quality IP systems around the world. And so they not only improve US laws, because we do have a government affairs team that sits within this group, but they are the ones that are primarily representing the United States and negotiating the treaties and other international agreements that we have currently with our sister agencies from around the world. They also provide a lot of training, outreach, and education to our international partners, as well as our sister organizations. And they sit in WIPO, and they are physically there to be able to negotiate and try to work with the countries across the board to be able to improve their systems. And so moving on to the next slide, just real quick, here's just a couple of the different agreements that we work on and that particular group works on. One of the most recent agreements that they worked on was a free trade agreement with Mexico, in which we were able to establish a program in which you were allowed to receive quicker examination from the Mexico Patent Office. If you have a US patent already granted, you could file that patent with Mexico and you could get a more expedited review on certain types of subject matter, depending on what the technology area is with that. And so this is the group that works on those types of agreements and is able to be able to put in different types of IP provisions with any of these trade engagements that they have. If you go to the next slide, please. That same group also has the Global IP Academy, and they actually were the ones that helped put this particular presentation together for me to be sharing with you today. They have a group of individuals who could do training as well as provide different outreach as well on international topics, and they could provide it in much more detail than I am able to share with you today. So if you have any questions, please feel free to reach out to them as well. If we could go to the next slide, please. If you do want to go to a particular country, we do have 14 IP attaches that are based in the consulate offices and the embassies around the world. And the responsibility of the IP attaches is to help you navigate the IP systems around the world. So for example, if you wanted to do business in China and you wanted to do some sort of manufacturing business, or you wanted to select intellectual property rights, there are IP attaches, 3 of them, as a matter of fact, in China, that can help you be able to navigate and find out which organizations you need to file with and the different groups of people that you should be working with. What the IP attaches can also help with is to be able to connect you with the US Commercial Services, who also sits in those particular embassies and consulate offices. And what they can do is they help US companies be able to find trustworthy manufacturers or other partners to work with in country. So for example, if you wanted to go to China, for example, and you were looking for a semiconductor partner or someone that was going to be able to help provide certain parts or manufacture certain parts for your products, then the USCS, US Commercial Services, can help you be able to navigate and figure out which organizations are probably the best match for you, and also be able to give you a lead on different groups and different companies to work with. It's sometimes a scary proposition to go into a foreign country, and that's what the IP attaches and the embassies and the consulate offices are there to do, to be able to help US businesses in the interests of US businesses as they are expanding globally, right? So next slide, please. The last slide, and this is going to be the case for any of the USPTO resources that we talk about, is that you can find any of this information on uspto.gov. In this particular case, this is the page for our Office of International Policy and International Affairs. And so you can find all of this information, the contact information for the IP attachés that I mentioned, some of the basics of the training that I just went over, and a deeper dive into some of the treaties that I talked about. You can find all of those links here on this particular website. So the last slide is just one more thing that I wanted to point out. Many people do go into China or they are experiencing issues with counterfeit. And so the question really is, okay, so I have now a popular product or a popular service and my product has now been knocked off. So what are the things that I can do to help be able to secure my particular rights, not only in China, but within the United States as well? And so we have what's called an IPR, an Intellectual Property Resources Toolkit. And so that is a toolkit that specifically addresses issues that you might be having with China, and specifically if there's any what we call fake products or counterfeit products that might be coming across the border. This is information and specific questions that you could have. Now, I do know that our China IP team is going to be starting up our China IP Roadshow again. It's usually a very popular roadshow that we temporarily halted during this particular time, but I do know that they are ready to start that up again. So if you are interested in hearing more about how to protect your IP in China, then that is a great roadshow for you to attend. And there's more information that will be coming out, and you can look for it on our events page at uspto.gov. So last slide, please. So that wraps up my presentation, and I am ready for any questions if anyone has any.
Steffi, did you have a question?
I can't write my questions in, but I don't know if you talked about this, but I know with the trademarks in the United States, they have like a filing fee, and then every so many years they have to submit that payment. Do they do that at the foreign countries also?
So for the USPTO, you're right. After you get your trademark registered, between the 5th and 6th year, you have to file a renewal. And then at the 10th year and every 10 years after that, you do have to renew, and you have to prove that you're continuing to use that particular mark in commerce. Similarly, there are different renewals that you have to do within each of the countries as well. And each of the different countries have a different renewal period. And so you'll just have to work through, once you get your particular application, or excuse me, your registration, you'll just have to work through whatever their renewal periods are to get that particular registration renewed.
Okay, thank you. And then also, do they, different countries provide a stamp, like we have the registered R, the R with the circle? Do other countries have a stamp also?
You know, that is a really good question, and I do not know what the answer is. And so I will have to get back to you on that.
Oh, I was curious to see, you know, because maybe you would know, oh, that's from a certain country because they have that symbol or whatever. So
yeah, I'm not sure. So I would have to ask.
I did attend that China, the IPR toolkit, and that was very impressive that we have people all over working for people with intellectual property and helping them stay safe. And it was very well presented. So everybody should
Good.
read that one.
I will let them know. I think they would love to know that. And yes, definitely, everyone should attend that. I do think there's a lot of really good information.
Hope, is that toolkit just specifically for China?
Right now, that toolkit's just for China, but I do know that the team is working on toolkits for each of the different countries. I think the next set, but don't quote me on this, I think there's going to be a toolkit coming out for Russia as well as Brazil, the BRIC countries, and maybe India. And so there'll be toolkits for that, but there'll also be toolkits for going into the EU, for example. And so they just wanted to hit the highest one first, which is the China one, which is where we get most of our questions internationally.
Here's another question. If you feel like going back to your jewelry patent or trademark or design, and you feel like you're not going to go internationally, but again, you said if you start to gain this popularity, when do you suggest moving into international patents and trademarks?
So my suggestion is that you would go international if you feel like you were going to either be manufacturing, doing any sort of R&D in that country, any sort of thing that would constitute movement of money or commerce, right? And so I think if that is the scenario that you're going to be entering into, then it may make sense for you to get a international patent or a patent or trademark, excuse me, in that particular country. Now, when it comes to products that are coming in counterfeit, the unfortunate part is that once you are a popular product, then the likelihood of being knocked off is going to be extremely high, even if you are not manufacturing the product or selling or even doing R&D in that particular country. And so within the United States, if you file a patent or particularly a trademark application within the United States, the benefit of that is that you can use Customs and Border Patrol to be able to stop the counterfeit shipment from coming into the United States and being sold in the United States. You have to have a registration with our office in order for that to happen. And so Customs and Border Patrol, once you get a registration with us, then you register with Customs and Border Patrol, and they are able to pull the mark and the types of goods and services that you are typically providing. And then they are able to stop shipments that are coming in that are not within those goods and services. And I say this because I went to go and visit one of the Customs and Border Patrol facilities down in Houston. And when I was there, everyone knows the Hugo Boss brand, and they sell cologne, right? And so, well, in this particular case, there was a shipment of crack pipes that came in with the Hugo Boss name. Now, if I was going to be smoking crack, I'm not sure it really matters what brand it is, but in this particular case, they knew that it was counterfeit because Hugo Boss does not sell crack, those crack pipes, and they are selling perfumes. And so they were able to stop that shipment from coming in, and they were able to notify the owner. Customs was able to notify the owner of this particular shipment coming in. That was probably a more detailed answer than what they were looking for.
That was great detail on that. And I'm glad we have some resources to stop that. So we do not have any other questions that have come in. Steffi, do you have any more questions? Oh, she does.
So on that Customs and Border Patrol, is it automatically registered once you get, or you have to do an actual application?
Yes, you do need to go onto the site to actually register with them and let them know that you have a registration. what is particularly helpful for Customs and Border Patrol is that a lot of times you, as the owner of your business or a particular product, you know if there's probably a shipment that may be coming in. And so what is helpful is that when you do register, you let them know, hey, we think that there may be something coming in. Can you be on the lookout for that? And that's something that will be helpful for them because they will then pay more attention to that. But you do need to separately register with Customs and Border Patrol in order for them to stop a shipment.
And then I have one more question, and it has to do with patents. And so once your time limit is up on your patent, does that become dead and then everybody can start using it to like manufacture? And does it happen like a big?
Yes, so for your patent rights, they are good for 20 years after the filing date. And so during the 20 years, you have a monopoly. And the monopoly, you have the sole right to to prevent anyone else from selling, manufacturing, using all of those rights that were listed before. And after 20 years, yes, those rights actually expire. And so the benefit is that you are sharing your knowledge with the public so you can advance technology forward. And by the advancement of the technology forward, and as a reward, you do get a monopoly. But after 20 years, then you give up that right and you now have shared it with, quote unquote, the public. But then hopefully at that point in time, you have now come up with a new product or an improvement on that, which can also be protected by patent. And you have made now improvements. And so you have another 20 years on that particular new invention.
Okay. Okay. I just wondered, I mean, I know I understood that, but I was like, is there a big explosion? Do they go out and everybody starts using it? So
I think the most popular one that you might see is in the pharmaceutical patents, right? In which you start seeing a lot of generics coming out after a particular product, the main pharmaceutical product has expired. Now, there are other laws that govern allowing generics to come out a little bit sooner than 20 years. But in general, the pharmaceutical companies, after 20 years, that particular formula is now in the public domain, and other generics can also start manufacturing that.
You also hear so many horror stories of people missing a deadline and stuff. So I think the thing is keep up with where you're at and where your company is at and stuff like that. Steffi, do you have another question?
no, I don't. But thank you, Hope. That was very informative. Thank you.
Thank you.
So we have coming up, and it's going to start in just a minute, but we're going to have David Irvin, who's with the Patent and Trademark Resource Center at New Mexico State University. And so I am going to stop sharing, and he is going to, whenever Steffi, you tell me he's ready, we can get him to share his screen and he can start his presentation. Then after that, we are going to have Jeff Nickerson, and then we're going to have Larry Udell. So I am going to stop sharing right now, and we'll get David Irvin up.
Okay, thank you.
Hi, Dave. Oh, huh.
Are you able to see my screen?
Yes. Yes, we're able to see your screen.
Okay, I just put it in full screen mode, so hopefully it's filling your screens as well. Thank you so much to the SBDC crew and to Steffi for providing me a little bit of time to talk about what I'm working on down here at New Mexico State University. And thanks to Hope, that was a really good presentation, good reminder of a lot of details that easily slip out of my mind. Right here on the first page of this presentation, I wanted to point out at the bottom, there's a picture of a gentleman giving a discussion, and it says USPTO training, Milton Hall, October 17th, 2017. I remember the date well because it was my birthday, and Hope was in town. She came down with a patent examiner, and they gave a great educational session at New Mexico State University. And one of the things I like to point out is that numbers don't always tell the story. So I was working on that event for a few months with Hope and the other individuals at the Dallas office. And then about a dozen people showed up from the community. And at the time, I was new to NMSU, and I was like, oh man, I wish, I booked a room for 40 people. Only a dozen came. But what happened in the next 2 or 3 years was pretty remarkable. 2 of the individuals who were in that room that day, who heard Hope give her presentation about patents, and this gentleman, 2 of those individuals got in touch. We did more research, and they moved ahead. And just last year, they both got in touch with me and said, yeah, I got a patent. So it was a great success story, really, of how collaboration between universities and the USPTO can be very helpful to communities and drive economic development and patents. So thank you for doing that, Hope. Hope we can work on some more projects going forward in the future. So my name is David Irvin. I'm the Business and Government Documents Librarian at New Mexico State University. I came in here in 2016. So I work with the Business College and their research needs, and I also am in charge of the office that receives the federal materials from the Federal Depository Library Program. We put those on the shelf so that people have access to all of the congressional hearings, for instance, all the agricultural reports that are printed and that kind of thing. As part of that, I'm also in charge of working with the public in the Ptrc. So I receive annual training to in the best methods for patent research and trademark research. And this is how I got in touch with the USPTO in the first place. So what is a Ptrc? It's a USPTO affiliated office that offers research and informational assistance to entrepreneurs and to inventors. And we provide these services for free to members of the public, to faculty at the university, and to staff at the university, as well as students at the university. We see a fair number of students coming over and saying, I've got this great idea. Can you help me figure out if it's unique or not? So those are great interactions. Always like working with the students. We hold educational events. I collaborated with Steffi earlier this term, and we did a presentation on patents and trademarks in this network. It was really beneficial. And then we provide sort of like research consultations by appointment. So prior to the pandemic, we would do this in person quite a bit. But what happened was we had to go off-site, close down the library's physical facilities, and we started up a Zoom consultation program in our reference department. So I was able to take advantage of that. And now if you're interested in receiving some research assistance in this area, you can actually book that time directly with me, and we can go on Zoom. It's actually a really great tool. Hope we continue to use it into the future. We can also talk on the phone. and hopefully in the not too distant future will be physically open again. Back in the day, I remember having many interactions. People would come out of northern New Mexico and they drive all the way down. And I said, well, we could have just had a phone call. But now with the Zoom, it's really, it's a very interactive kind of consultation. So I can show physically, you know, the tools are visually the tools that we suggest that you use. We're also here at NMSU in the government documents area. We're the Plant Patent Depository Library for the state of New Mexico. So I think that agreement goes back to about 2002. But all of the plant patents that are printed by the USPTO are sent to my office, and we count them. We make sure that they're in the volumes correctly, and then we bind them and put them on the shelf. So if you're into creating plants, then this is a good resource in New Mexico to do research on plants and the different kinds of plants that have been created since 1930. In fact, we have all of the plant patents all the way back to 1930 in microfiche, and then we have these physical volumes here that you can see on the left. Where are the Ptrcs located? Well, they're all over the country, as you can see on this map here on the left. They're in city and public libraries, they're in state libraries, they're in special libraries, and then in this case, many of them are in academic university libraries like we have here at NMSU. So you can kind of see that they're very dense in the eastern half of the country, but as you go further west, they kind of thin out. Kind of makes sense. There's a lot more land and fewer people going west. And if you look here in New Mexico, you'll see that this dot represents Las Cruces, New Mexico. And it's the only office like this in the state of New Mexico. That's why we hear from people all the way up in Farmington, Clovis, Roswell, and also, you know, people coming out of West Texas will get in touch in El Paso because we are really out here, kind of isolated, hundreds of miles from the nearest Ptrc office. This picture on the right, I call this my action shot. This was taken by the marketing and communications department here at NMSU when I was helping this gentleman do some patent research. So this is what it looks like physically in the research office. And down here at the very bottom, I've included a graph that shows our page hits on this resource. And you don't really see much of a drawdown during the pandemic. And I think that's because we were able to move into the virtual realm pretty effectively. Just a quick slide about IP in New Mexico. So the majority of patents, we've done some research on this, are concentrated in Albuquerque, Los Alamos, and Santa Fe, which makes sense. You have federal laboratories in some of those places. You know, and then this graph below that, the top part kind of shows the smaller areas and what the patency looks like in those areas. So far fewer in Las Cruces than in Albuquerque or Los Alamos. That is to say that there's a lot of untapped talent and potential in New Mexico, and that's my belief. And the reason I have that belief is because I see it all the time. People call me up or come to my office or have a Zoom consultation with me, and they're excited about their idea. They want to, you know, plow through the process and figure out how to get protection so they can start a business, or that they've already started a business and they want to get their logo, they want to get their word trademarked, and they want to go with it. And what I see every single day, well, not every, you know, every week probably I see somebody, is just people who are energized, activated, and want to build the New Mexico economy through their own business ventures. So I'm very excited about that. I'm excited about business in New Mexico, and I love this state. So I hope some of you who are here today will get in touch. Oh, do we lose my, oh, there it is.
Do we have any questions for Dave? Can you hear me?
I can hear you. I think there was one more slide, and it provided
Okay.
some contact
Okay.
information for me.
I didn't see your slides moving forward, so I think Leslie took only.
Oh, okay. I'm sorry. Yeah, I don't know what happened there. Well, we'll share. I
One
think
more
y'all have
slide.
the slides to share, and there's some contact information and how to book an appointment if you wanted to go through this research process with me. So thank you for your time. Thank you for the opportunity to talk with y'all, and I'd be happy to answer any questions if there are any.
Oh, thank you, Dave. That was nice. We did have a great time when we did the patent searching and the trademark searching. That was very good.
That was great. That was great.
And we did have more attendees here, so I think that's good. And thank you for coming again. I look forward to working with you in the future and providing more webinars for our people in New Mexico. So
absolutely, yeah. Look forward to that, and yeah, I just encourage anyone who's interested to get in touch, and we'll do some research.
yes, and I know that the New Mexico Small Business has your link, and when they have training sessions on starting up businesses or with their products, that they contact you also. So that's good.
Wonderful. Thank you.
We have to support each other here in New Mexico. Go ahead, Leslie.
I was just going to say, I last time we did the trademarks and patents and stuff, Dave, I don't remember the beard, but it looks good. And I always like you coming on and giving us the great information. We're going to have Jeff Nickerson up next. We have a couple minutes. Jeff, do you want to go ahead and start, or do you want to take a 5-minute break before we get started? It's completely up to you.
We can go ahead and get started.
Okay, if you want to share your screen with everyone.
Yep, give me 1 second.
Okay, great.
And can you guys hear me fine?
Yes, we can hear you. And if you'd like to do a quick introduction, that would be great also.
Hi, my name is Jeff Nickerson. I am a supervisory patent examiner at the USPTO. I've been with the agency for about 14 years now, and I'm a supervisor in the security working group where we examine cybersecurity-based applications. We've got about 225 patent examiners. Year over year, we've seen filings increase in the cybersecurity working group. About 3 years ago, we were averaging probably about 9,000 patent applications every year. This past year, we're up to about 10,500. So it seems to be trending upward about 300 to 500 applications every year. We're not the fastest growing working group within the USPTO. That's probably going to be like artificial intelligence or something like that. That's exploded recently. And even in the what we call the electrical arts, we aren't even in the largest. There's a whole lot of other communication technologies that have more examiners and examination firepower relative to us, but it has been growing pretty significantly. And what I was going to go through today is a technical overview of cybersecurity. Our examiners, when we hire them, they go through a 4-month training academy. And specifically the cybersecurity examiners that we hire, we give them a fairly in-depth training on various cybersecurity topics. This is an abbreviated version of one of the earlier trainings they get. So it's a good background on a lot of different cybersecurity topics. all the topics that we'll discuss today, if you were to invent something in that field and file a patent application on it, it would come to our examination group, and we would be looking at it, determining whether to issue a patent on that. So it is technical in nature. It's not too deep mathematically. There are probably going to be some terms that we're going to just say at a high level, but of course, you always have an opportunity to do more research into them if you so desire. Okay, so the point of security and cryptography is essentially to secure communications, and you're going to see reference to Alice and Bob, even in very mathematical papers and stuff. All the researchers, they always use the same Alice and Bob as the individuals that are trying to communicate, and we call eavesdroppers individuals who passively monitor communications and try to gain information from what that communication contains. And that would be, for instance, you put a letter in the mail that transfers through the postal system or UPS or what have you. There's a lot of individuals that could have access to that information. Those would be eavesdroppers. And then we also have what we call attackers. Those are an active actor within the system that is attempting to perform some type of malicious activity. And if you're using the internet, all of this is done being most commonly with the hypertext transfer protocol. So this is an overview of the different type of attacks that cybersecurity tries to prevent against. So the first one is that interception-based attack, and the counterpart for security that we deploy to prevent interception-based attacks is something called confidentiality. So if we can communicate a message confidentially, then someone looking at it won't know what it means or be able to interpret it. And then various attacks that actors can employ against a communication system. They can modify a message. So you see there in the second diagram, the attacker is the orange dot. If I have to communicate through someone to get to you, that person that's in the middle can modify my message, right? And change it in such a way that when they give it to you, it could contain different meaning. If that person has malicious intent, they can change that message to mean whatever they want. And we call those man-in-the-middle attacks. Another type of attack is fabrication. And that is where someone impersonates me. They could come to you and say, hey, I'm Jeff Nickerson. I'd like to withdraw $2,000 from my checking account. If the bank does not properly authenticate that individual, they might take them at their word and they would get money out of my banking account. So authentication is the mechanism we use to prevent against fabrication-based attacks. And authentication is essentially just verifying the identity of the source of the message. And then there are interruption-based attacks. We counter that with availability, or high availability is what it's called. That's essentially a malicious actor interrupting, interfering in some way, whatever system has been built to communicate. They are able to do things to that system to render me, if I'm sending a message to you, that from not happening for some reason or another. The message, gets dropped in the mail, or it's just not delivered to you. It could be preventing me from even initially sending the message. And so this is what we sort of already briefly discussed, but those are the services or the pillars of security that we seek to establish within the cybersecurity realm to prevent these types of attacks. So confidentiality. This is the definition for confidentiality, and essentially it is ensuring that the information that is being communicated is not accessed by an unauthorized individual. It doesn't necessarily have to be a communication system. It can be stored data. So if you're storing information files in a filing cabinet, you put a lock on that filing cabinet, and only the individuals who you want access, you give them a key to that filing cabinet. They're the only individuals that can access that. So A lot of the concepts that we'll discuss are not exclusive to communications. Some of them are, but there's a concern, of course, for cybersecurity in stored data as well. Availability, we already discussed a little bit. The attacks are generally called like a denial of service attack when they're trying to interfere with your ability to communicate or access services. Lots of times, these are tied into not necessarily malicious actors, but just like disaster recovery and things like that too, where, if the cellular network fails, towers go down, how do you communicate with somebody across the United States? And there are, mechanisms in place to via radio, and usually it's legacy-based systems that were built way back in the day that are used to provide alternative means of communication or accessing a particular service. Integrity prevents any altering of a message, and it doesn't necessarily prevent the message from being altered. However, it allows the recipient of the message or the reader of stored data to identify that it has changed. And so we'll discuss that a little bit in detail. It doesn't always allow recovery of the original message. It's considered in a lot of systems good enough if the individual can detect that it has been changed, and then they know not to trust that message or information. And then authenticity, that's just verifying the source of the information and verifying they are who they say they are. So confidentiality is accomplished with encryption, and that is the use of codes to convert data so that only the intended recipient will be able to read it using a key. So if you're attempting to send a message, you're going to pass it through a source crypto system. It's going to become a ciphered message or information. Ciphertext is what we call that. The receiving system will have a crypto system that is going to be able to decipher, decrypt, decode that ciphertext and translate it into something that is understandable and readable. Here, Alice and Bob are trying to communicate. Bob will convert his message into a ciphertext, pass it onto the internet. That ciphertext is received by Alice. Bob is going to use some type of encryption algorithm or function and apply it to that message before he sends it. If an eavesdropper is listening in the internet and they hear the message or read the message, they're going to only be able to see the ciphertext. And Alice, of course, is going to be able to decrypt that message back into its plain text and understand it. So there's a whole bunch of different ways that individuals classify encryptions. They do it a lot based on the mathematical operation that's used to manipulate the plain text. Substitution and transposition are two very simple ones. It's based on the way that the plain text is processed. There they split it up a lot on whether it's a block cipher versus a stream cipher. There isn't a whole lot of difference there. The main difference is a block cipher is the absolute size of the information you're going to be transmitting, and it's a fixed amount, and then you break that information into blocks and then encrypt it on a block by block basis. The stream cipher is algorithms and techniques on a potentially infinite incoming source of information. It's just like a stream of data you're receiving over time, and you process that information and encrypt it. You can still do it on a chunk by chunk basis, but you just don't know the absolute size of the entire stream while you're processing. So it's kind of like on the fly encryption of just an arbitrary sized data that you're receiving and transmitting. And then they like to break up symmetric versus asymmetric key systems. All right, so a little history on encryption. From the beginning of time to roughly through the 1960s, all encryption was using three basic forms of encoding or encryption. and that was substitution, transposition, and then steganography, which is a little bit different. It's not quite encrypting anything, but it's basically steganography is like hiding a message in plain ordinary view. It's if you've established meaning of something that an observer would notice, and they know the meaning, the hidden meaning behind it as well. But the average individual looking at it would think it's just normal, ordinary business, or not a secret message at all. A common technique for steganography would be like, if I put a classified ad in the paper for a 1969 Chevy Corvette, red in color for a certain price, that means I want to meet with you at a certain time and location. Anybody who sees that is not going to think that's a hidden message. Substitution ciphers and transposition ciphers. You see that Enigma machine, that was a big one back in the World War II. You can go back to the early history where they would encode messages. The Zodiac Killer, his published ciphertext, where it's simply you're substituting like a letter for what the original message would have been as your ciphertext. And transposition is something very simple and similar. If the letter A is a 1 and the letter B is a 2, you could do some type of like shifting where you just always add to every letter, 5. And then, all right, so if you wanted to use the letter A, that'd be 1 plus 5, that'd be a 6. What is 6? A, B, C, D, E, F. So you write F in your ciphertext for your communication. So it's sort of a combination of substitution and what you're performing some type of mathematical operation rather than just substituting every letter A in your message with an arbitrary different letter. In the 1970s, there's some mathematicians, Ralph Merkle, gentleman with last name Diffie, a gentleman with last name Hellman, who came up with the theory that is all the foundation for all modern encryption up until very recently. And that is the ideas that they set forth are that, well, instead of doing sort of these very simple mathematical operations, there has to be a way that we can mathematically translate a message into a ciphertext and make the math required to reverse that operation extremely difficult. And so they looked at a couple of different areas of mathematics. But first, we're gonna talk about, I guess, trapdoor functions. A trapdoor function in mathematics is sort of what I just described. It is a function which is very easy in one direction. So an example of that is multiplication, right? If I give you 2 integers, you can perform multiplication on those integers very easily. The other aspect of the trapdoor function is that the reverse operation can be very difficult. It can be very computationally intense, right? So an example of that is factorization. If I give you an arbitrarily large number and tell you to factor it, you're going to have difficulty, right? You're obviously like 1s and 2s are going to be easy, but if it's extremely large and you're trying to find all the factors for a number, you basically just have to guess. And there's several factorization algorithms out there that sort of like optimize the time it takes to determine all the factors of a number. But going the other way, if I just give you 2 numbers, you can multiply them together and you can find out, okay, well, these 2 numbers are a factor of that larger number. And all of our conventional encryption from the 70s through the 2000s is based on 2 mathematical concepts with what we call trapdoor functions. And those are factorization and the elliptical curve. The elliptical curve is a geometric problem. If you imagine a Lululemon logo and turn it on its side, that is a elliptical curve, or like the capital omega in the Greek alphabet. That's an elliptical curve, and there's, again, a math problem. Mathematicians love to create these problems and then solve them. And that math problem involves, if you draw lines through this elliptical curve that's on a graph, it'll intersect it at most 3 points. And so it's essentially like playing billiards. You draw a line up and you hit the curve and then you bounce to the other side of the curve and then you use that to draw another line through the line you're. So there's this sort of like geometric problem with elliptical curves that is, if you're doing it, it's very easy, right? Because you're going from start to finish. But if I give you one segment of that bounce in that graph, you can't figure out where I started and you can't figure out where I'm ending up without a significant amount of computation and guessing going on. And then there's more recent encryption, which I've dubbed here New Age Encryption. And that's really picked up interest in the last 5 to 10 years. So quantum computing has become more prevalent within the last 10 years. And you know, quantum computers, those are like, they're mainframe computers that are existing in like research facilities. So they're not, you know, you're not going to be having one sitting under your desk anytime soon. But the previous conventional encryption, which we just discussed, the mindset behind it was that, well, solving these math problems takes millions of years. And then we came to quantum computing, and the mathematicians essentially were like, well, let's try to break factorization and make it, you know, really easy and figure out how to do it. So a mathematician named Shor came up with a new algorithm specifically for factorizing, and he was able to calculate factors of arbitrarily large numbers in hundreds of hours and not millions of years if he used basically these super quantum computers. And the highest he's broken is a 829-bit key, which is 250 decimal digits, right? So they're generating this huge number that's 250 decimals long, and he's able to calculate all the factors of that with his algorithm in hundreds of hours. Whereas before this, people said, okay, 250 decimal digits long is your encryption key. You're not going to be able to calculate that out for, you know, many years. And so that has created concern in the theorists of encryption. And NIST, the National Institute for Science and Technology, they do this thing every few years where they sort of do a playoff. And there's multiple stages to it, but they're always seeking to improve cryptography and the security standards for communication. And so they basically take papers from mathematicians who are in this field and researching it, and they sort of select, you know, the best one every round, or the best top couple every round. And they, you know, then once they select one, then the math community as a whole, you know, they analyze with great scrutiny these different algorithms and things like that. And eventually they whittle it down and select their top tier. And some of them are going to be based on different mathematical concepts. But NIST is sort of like this mediator, this grand facilitator in what cryptographic algorithms are generally adopted and accepted in the entire world. And it's important because all the communication systems that you're using right now to access the internet and to access your banks and to do all of this, quote, secure communication and things like that, it's all predicated on this classical and convention encryption that's already existed, right? So it takes time. Once these theoretical, this is the best way to go about encrypting something, is selected by NIST or whoever, it takes a while for, you know, all the computer companies and individuals who, you know, the Bank of America, all these people, it takes a while for them to implement and adopt all of these standards and recommendations. And so the new age encryption stuff it's stuff that is hard to solve both with classical computers, which we're using now, and then the new quantum supercomputers. So they've implemented, or they've discovered, these various sets of mathematical problems that are extremely difficult to solve in the reverse direction, but are easy to do in the outgoing direction. And that's important because the end users and computers need to be able to calculate the keys, right? Like it needs to be easy for people who are trying to communicate using this encryption technology to generate the keys for it and then encrypt and decrypt the data. We don't want that to be so computationally intense that, you know, it takes minutes for you to send a new message to somebody, an email or something. But the reverse, anybody who's trying to inverse that mathematical operation that you use to encrypt it, we don't want them to be able to solve it like trivially. So you see here the lattice geometry of numbers. I won't go into these too much, but you can look into them more. They're all very complicated and interesting topics if you're into that sort of thing. So symmetric encryption is the concept that you use the same key to encrypt the information as you do to decrypt the information. And so the problem and flaw with this system is that you need to exchange the key ahead of time, right? So like, how do you do it? Well, in World War II, you know, you were physically interacting with the individual, so you gave them the key. And then you sent them on a mission. If you need to send a communication, they already have the key, they already knew it. If you're trying to initiate communications with someone who's already remote and you need to negotiate the key ahead of time, it becomes very difficult. Public key cryptography, known as asymmetric key cryptography, was created in the 70s by Diffie-Hellman and Merkle. And it tried to solve that problem. And it tried to do it by essentially saying you can encrypt data with one key and you can decrypt it using a different key. And so the key that's being used to encrypt the information, you can make public. And then the individual who knows the public key will be able to use a secret key to their own secret key to decrypt it. So if you wanted to send a message to me, I would give you my public key. You would encrypt the message with my public key and send it to me. And then I know my secret key. I haven't told anybody my secret key, and I can decrypt it with that private key. And inversely, if I wanted to send a message to you, you would tell me your public key. I would encrypt it using your public key and then send it to you. And then you can decrypt it using your own non-disclosed secret key. There's no need for a secure channel for the key exchange. And this paradigm of public key cryptography implements both authentication and confidentiality. But one of the key concepts here is that it's involving factorization of this public and private key. So the public key that's being disclosed, it's that very, very large number, right? So somebody can overhear it and they're not going to be able to guess what your private key is without a lot of math that's computationally intensive. This is what we just described. You can exchange the public key in an unsecure manner, and then Bob can encrypt it, and Alice is able to decrypt it with her private key. We've sort of already discussed this. This is the RSA algorithm, which is introduced by Ribish, Shamir, and Alderman in '77. It's based on modulo mathematics, which is like carryover remainder division. And it's based on if you know n, you can't feasibly in a reasonable amount of time calculate what p and q are. And then briefly discussed elliptic curve cryptography as well. Again, it's a graphical based mechanism to sort of establish what the shared secret is going to be, something you can announce publicly, and it's very difficult to sort of reverse that process. So what are the benefits of symmetric versus asymmetric? Symmetric is extremely fast, right? You've got short keys. It's very easy and fast to encrypt something. So if you had a huge email that you're trying to encrypt, it doesn't take a lot of computational power to encrypt that email before you can send it. Similarly, when it's received, it doesn't take a lot of time to decrypt that message. The bad part is that you have to exchange keys and you have to have a secure channel to do that ahead of time. Asymmetric, there's a lot more handshaking going on ahead of time, right? You've got to tell somebody your public key. You don't have to have a secure channel, so that's a plus, But now you have to sort of manage keys. There's a lot more going into generating the keys, and it takes much longer to perform the actual encryption algorithm on the message you're trying to send. What happens in reality is they do this asymmetric as at the very beginning, right? Like if you're trying to talk to somebody new, and then you exchange over your secure asymmetrically encrypted channel, you exchange a symmetric key. And then going forward, both of you use the securely exchanged symmetric key for all your encryption and decryption. And they're all ephemeral. A lot of times they add all these types of considerations in where the keys time out, you have to renegotiate a new key. And there's a lot of considerations for managing the keys. You got to have somebody trustworthy that's sort of like overseeing it so that I don't use the same public key as somebody else, and now we're both using the same algorithms and things like that. Integrity is securing against tampering of the message. So here we use something called a cryptographic hash function, and we put the message as input into it, and you get out a hashed value. And a couple things here is that the hash function is non-invertible. That means you can go one way and get the hash value, but if I were to tell you the hashed values, you would never be able to go back to what the input was. And the other thing is no two inputs give you the same output. So it's unique, and it's of fixed size as well. So the hash, if you have two different messages going in, you're not going to have identical hash values come out. They can be keyed or non-keyed. If they're non-keyed, that just means the uniqueness has to happen in the hash function. We quickly realized early on that that's not good, and we need to add sort of like a randomness as input to the hash function other than just the input message, because then what if someone finds out your hash function? They can create a lot of problems for you. And so modern systems use a key as input to the message into the hash function. So how do you use all this information to verify the integrity of a message? All right, so the sender has a message he wants to send. He sends the message to the receiver, right? The sender separately takes the hash function and applies it against his message. He gets a value out, this message integrity code. He then transmits separately from the message, sometimes appended at the end, this message integrity code. The receiver has now received the message and the sender calculated message integrity code. The receiver then separately calculates, using the hash function, the message integrity code on the message that he received, and then he compares the message integrity code that he received versus the one that he calculated on his own. If they don't match, that message has been changed in transit, and he did not receive the message that the sender sent. Message authentication code is one where we're doing all of that with the key. It's essentially the same process, except now that you're using the key of the originator to calculate the message authentication code. And so it provides authentication as well. You can verify that it's actually the sender who is sending that message. So speaking of authentication, this is implemented via digital certificates and signatures in a lot of systems. Think of a digital certificate as your driver's license for cyberspace. It is a unique identity that allows you to prove who you are. It's issued by a third party, which we'll get into a little bit. And you can use a code that is typically contained within your digital certificate to sign anything, a message, a document, whatever. And once you sign that document, something called non-repudiation against, which is another pillar of security, we'll call it. It just means you can't like go back on your word. If you've done something and signed it, you can't go back and change what you signed. it's still in its original state, basically. So this whole third-party trusted system for issuing certificates is called the public key infrastructure. We have certificate authorities there in the middle, CAs. Users will go to a certificate authority to be issued a certificate under that jurisprudence. So that'd be like if I went to the New Mexico DMV and got a driver's license from them, right? If I'm now at a bar trying to get alcohol and they're carding me to make sure I'm 21 years of age, I show them a driver's license issued by the New Mexico Department of Motor Vehicles. They look at it, and do they trust it or not? Well, I don't know. Do they trust the New Mexico DMV, right? So this system requires the trust of a third party that is issuing certificates. How do you get a document from the New Mexico DMV? Is there like a workflow process where you have to prove who you are, or can you just walk in and say, I'm Jeff Nickerson, and anybody can get a New Mexico driver's license that says Jeff Nickerson on it? There's probably other forms of identification required. So if you imagine like the root certificate authority there at the top is like maybe the US State Department, right? If they were responsible for issuing a birth certificate at birth to all US citizens or a passport or something, you can then go to a regional certificate authority and have them locally issue you a certificate that proves your identity. So there's this sort of hierarchical structure to that system. And you can use those keys or certificates that contain a key to hash a document using your key. And anybody who looks at that document can decrypt it using your public key. You hashed it with your private key, and verify that you actually were the one to sign it, because they can go to the certificate authority who issued that certificate and say, hey, is this Bob's actual public key? And if it matches, they know that you in fact did sign that document. So that's a brief overview of sort of the goal that was achieved from each of those security mechanisms. Further considerations that these systems have for authenticating the users, they check to see if it's something you know versus something you possess. Like a driver's license is something you possess. Knowledge factor would be like a password or a PIN code. Do you know the secret passcode to get in? Inherent factors are something called biometrics is the example there. And then multi-factor, you have to have more than one of these in order to gain access or be authenticated. And then there's mutual authentication. That's just each individual is able to identify each other in the communication. There's forms of access control, which are going to be performing authentication on the user and based on the object, where you may have read permissions of something but not write permissions. So in order for it to make that kind of decision making, it's got to evaluate permissions levels of objects, permission levels of the actor trying to access that object. And there's a whole bunch of different access control paradigms that are used to control access to data and information. They can do it based on your role, whether you're a supervisor or just a regular employee. Discretionary is an interesting concept. It's what the DoD actually implements, and that is that when you're creating a document, the creator of the document dictates the access control levels for that object. Whereas mandatory would sort of be like it's set by this omniscient entity managing the system. And then we're going to touch on availability here. Availability, again, is ensuring that you are able to communicate and that your service is not being interrupted. The two main architectures to implement that are detecting some type of intrusion in your system and then preventing that intrusion. Firewall is sort of the colloquial term that's used in a lot of these implementations. And firewalls can filter traffic and information based on a lot of different properties. Just on your home router, there's a default firewall that blocks all incoming traffic unless you've already attempted an outgoing session, right? So there could be people in a foreign country probing your firewall on your router, trying to see what ports you've got open or what services or anything like that on your router. Hopefully your router is by default blocking all that traffic and just not responding to any of it. Denial of service, and it's a child distributed denial of service. This is essentially when users spam a server. You'll see it's less of an issue now with a lot of these cloud-based services, but back in the day, you would have seen, you know, your bank, some banks would go down and their website would be inaccessible because they were, quote, attacked with a denial of service attack. So this is where the clients, or impersonating a client of the bank, they would just constantly request, you know, from many different computers throughout the world. It'd be distributed, and they would just spam requests. You know, every 5 milliseconds, they're sending requests to that server. Well, the server is now getting millions of requests from all these different computers all across the world. What happens? Its memory and buffers overflow, and it can't respond to them, and it crashes the computer. And a lot of times there's impersonation going on there on the client's part. Here's an example. Again, most of them are distributed now, so they have bots just sitting out on all these different devices now. And at some command is sent to all the bots, and all the bots will start sending requests to a specific target, and it'll end up with that website crashing. It's very easy to detect when that's going on. If you're the bank under attack, you've all of a sudden skyrocketed the number of requests you're receiving from Russia or China or something. You can detect that early on, but it's very difficult to stop based on depending on how distributed it is, right? Like if you're getting all these requests from Russia and you know you're not supposed to be getting requests from Russia, you can just block all those. But if they distributed the bot networks and now that it's all across the United States as well, it's like, well, we think that's regular normal client traffic, so you might be allowing that traffic to hit your servers. Here's another great example. That is UE attach and detach spoofing. So UE is a user equipment. That's like your cell phone. That's the telecommunications company call it UEs. You're connected to a particular base station or access point, a particular cell tower, and something that happens during the normal course of business is if you're moving, right, geographically, spatially, you're moving to another base station's area of responsibility, you will hand off your cell tower, or your cell phone will hand off itself to a different cell tower. That's all great. That's been implemented for seamless transition, so you can talk on your phone while you're driving, right? So that handshaking that occurs during that handoff, you actually, as the UE, tell that cell tower, hey, I'm leaving like your zone of control. I'm going to start talking to tower number 2 over here because that's where I'm headed. If that cell tower does not authenticate that message of yours, that means somebody could spoof your phone and tell the cell tower, hey, I'm disconnecting and going to start talking to tower number 2, but you're still sitting here in tower 1 zone of control. So that's another example where someone is spoofing your handset and they cause you to lose state of your connection with the access point. And even if you identify that, your user equipment identifies, oh, for some reason this tower doesn't think I'm connected to it anymore, I'm going to reestablish my connection with it. There's a whole procedure to reestablish your connection with it. So it all takes time, and they can constantly connect you every time you reconnect and things like that. So the towers can detect that that message is fabricated and it's not actually coming from you, but they have to perform authentication on all those signaling messages that they're receiving, which makes it computationally intensive for the access point. So with a lot of these things, you can see computational intensity is a heavy consideration with exactly how much security you're implementing. So I hope that was interesting. The last thing I wanted to touch on is the CPC, which is the Cooperative Patent Classification System, and it's how we classify applications that come into the office and sort of route them to examiners. These are the 5 main CPC symbols and main groups that our work group handles in the cybersecurity field. So if you were to file an application or you're doing research or inventive subject matter in one of these areas, that would likely be coming to our main group. And as Paula, I think, spoke to earlier, we always highly recommend searching before you file a patent application to see what's already out there, what's already been done, and make sure it's a good idea that your invention is different from what's already been done out there, because that's a key thing that examiners look at when they're examining an application. And so these would be the CPC symbols that you could be searching in. And this is a list of some of the upcoming events that we're having virtually. I believe all of these are virtual, but Paula would have more information on that. That is all the information that I have. I hope it was very informative. And without further ado, I will turn it back to our moderator.
Thank you, Jeff. I see it's Jeffrey. Is it Jeffrey or Jeff?
Either one is fine.
Okay, we had a lot of information on that, and I got a little nervous there for a minute. Steffi, do you have any questions?
Oh, I thought that was a very informative. I know that we've been having a lot of cybersecurity breaches, and they've been hard to find them. They've been sitting on people's servers, but now see that I think one of them is changing even the hashtag, so then they can't even see if there's a difference in it. But this was a better understanding of what's going on. Very good, Jeffrey. That was very good.
Thank you for having me.
Thank you.
And people are using more encryption, right? For their security.
Yeah, I would say there's definitely a lot more awareness regarding the security of communications. And like you said, with the data breaches at large companies and the databases they have of just their customer information, there's a lot more awareness and proactive measures being taken, I guess, to protect that information.
And are more patents coming out regarding the cybersecurity with these big breaches coming up?
Yeah, so we're seeing, we've had, in the last 3 years, we've had an increase of about 1,000 to 1,500 applications in our working group. And then similarly, we're issuing patents at a much higher rate as well, based on those increase in filings.
Oh, that's very good. Keep us safe.
Awesome. Thanks, Jeff. Okay, we're going to take a 5-minute break. We're going to start at 2:15. And with our guest speaker, Larry Udell, and Larry's going to have to tell me if I have pronounced his name correctly, but I hope I have. And it's going to be just at, well, 4 minutes now. So we will pop off and we will be back on at 2:15 Mountain Central Time.
1 minute.
Okay, I have 2:15 Mountain Standard Time. I'm Leslie with the New Mexico Small Business Development Center. Steffi, would you like to introduce our guest speaker today?
Okay, we have Professor Lawrence J. Udell, who has, just a minute, has been a new venture consultant to New Mexico Tech since 2015, and he is the creator of the very popular Inventors and Entrepreneurs Workshop. And he's going to be having the event in October 14th, and I'm thinking that's going to be around 49ers time, but I'm not too sure. But welcome, Larry, and you can go ahead and take it away. You have to unmute yourself in your lower left-hand corner. You'll see your little microphone and make sure. There you go.
How's that?
So
I just
much better.
I just wanted to tell Jeff that I really appreciated his presentation, even though I very little understood it. Let's put it that way. All right. Intellectual property. What is it and how do I join it? In other words, how do I make money off of my creative abilities? Next, please. You've heard this all morning, the 4 types of intellectual property. I won't belabor the point by going into any details. We already know it. Next, please. Okay, just a little bit about me. You've heard something about me already, but I started teaching entrepreneurship at the university in 1982. And I guess my one claim to fame, if I had a claim to fame, would be that I left my last employer. The person that, or company that told me what to do and where to go was in March of 1964, 57 years ago. So for 57 years, I have had only one boss, and that's my wife of 61 years. Anyway, I've done a lot of work with federal agencies and also have taught new ventures at universities throughout the US and overseas, and have created educational programs for federal agencies, plus the USPTO. Next, please. Valuing IP. When you look at intellectual property, it has produced last year, 2020, the income to the US corporations of $143 billion. That's licensing revenues that were generated through the protection of that technology, that intellectual property. And you'll see in a few moments who was receiving those billions of dollars. Next, please. What do I need to do to earn money from licensing? Well, quite simply, and you've already heard this. It starts with an idea, an invention, Ideas are of no value unless you do something with them. Ideas become inventions. Then you file for a patent, hopefully after you've done your homework, your research, in-depth research to determine whether there's something like that on the market or had been patented previously. Even if it was patented 100 years ago, you can no longer get a patent for it. And companies do not buy ideas. They buy the results of the earnings of those protected inventions. Let me give you just 4 brief examples of people I have worked with. Jim Ferguson, who you have not heard of, was the father of LCD, liquid crystal display technology. He revolutionized the entire industry of watches, TVs, computers. It was mentioned earlier by Hope, I think, that how do you maintain value of your idea, your patent, and so forth? Simple. That's what Jim did for years. He kept inventing around his original technology. And this resulted in 150 US patents and 350 foreign patents. And this also then resulted in approximately, I'm going to hesitate here, $32 million a year of royalties based on his patents. He locked up the industry by continually inventing around his last concept to where he had total control of the LCD industry worldwide, which brought him that kind of income and all the major corporations knocking on his door for a license. The second is Forrest Bird. Forrest was an American aviator, inventor, biomedical engineer, best known for creating the first reliable, mass-produced mechanical ventilators for acute and chronic cardiopulmonary care. He was the oldest helicopter pilot in the world when he passed away in August of 2015. But he got his pilot's license when he was only 16 years old. How he came up with this device was at high altitude flying. He realized that the higher you go, the more oxygen you need, and how do you get it? And that was the result of his first invention, to be able to breathe at high altitudes. He received several presidential awards and was best known for inventing the baby bird, which is in every hospital in the world today and has saved literally thousands of newborns because of the breathing. 60 Minutes, CBS television program, has done 2 special programs honoring Forrest Bird. Third example is Bob Parker. And Bob started with, maybe most people remember, the mood ring way back several decades, which changed colors based on the wearer's mood. His fame as a successful inventor, however, was really demonstrated with the Duracell battery tester. Its Duracell battery tester is now on the battery itself. It was on the package when he first came up with the idea, and it took us over 4 years to perfect someone. And remember, there was only a limited number of battery companies. There was only 5 battery companies at the time. But it took 4.5 years for Duracell to say, okay, we'll give it a try. They did. It went on to increase their percentage of the market dramatically. And Bob eventually sold his rights to Duracell, so they stopped paying him a royalty. Now, Bob spends most of his time, Bob and Nancy, either at their home in Southern Oregon or in Palm Desert, either on the golf course or playing tennis. This is the result of successful inventing. My last example is a very charming, beautiful woman named Barbara Carey. If you've never heard of her, look her up on the internet. The first year that she put her product on the market, called Harigami, she made $40 million. Everybody hear that? Okay. She also wrote the book on Ideas Are Worth Millions. These are just 4 examples, and I say only 4 out of hundreds, maybe, well, actually thousands, of successful inventors who have done something with their inventions, especially in the area of licensing. If it was not for the licensing opportunity, Jim Ferguson, Forrest Bird, and so forth, and Bob Parker would not have earned that kind of income. Next, please. So here's the 2020 licensing scorecard. Walt Disney Company made $54.7 billion last year off of licensing their characters. This is only off of licensing. And Disney is well known in the industry as you don't touch a Disney created product or you'll have attorneys breathing down your neck immediately. The Meredith Corporation, which is in magazines, media, TV stations, and so forth, earned $26.5 billion. Authentic Brands, which owns the rights to several passed away or dead celebrities like Marilyn Monroe, Elvis Presley, and so forth, earned $12.3 billion. Warner Media, as you're all familiar with, HBO, magazines, Turner, and so forth, $11 billion. And so forth. You can see on the screen the others. Even Hasbro Toys brought in $6.9 billion in licensing their protected toy products. So these are examples, these are extreme examples, success examples of money earned off of intellectual property and the value of licensing. Next, please. So how big is the industry? Well, for your information, there's 1.3 million attorneys in the United States. I know most people think there's millions and millions. But out of those 1.3, there are 34,000 registered patent attorneys. This is an example of how big a market intellectual property is. Next, please. So let's look at how valuable is my IP. Let's bring this down to a home level. How do you analyze, for you, the viewing audience, how do you analyze what is my intellectual property worth? Well, you start off with, first of all, have you done your homework? I'm going to deviate from the slide. Have you really done your research? And I don't mean walking down the aisles of Walmart to see whether your product is on the shelf somewhere. No, that's not research. You go into depth using the internet to find out, first of all, has there ever been a technology or invention patented? And if there has been, you cannot get a patent for it. They will not issue a patent for one that has already been issued. You also need to look at how large is the market. Is it a big enough market to justify what you're going to be spending and the time and energy and effort and dollars in turning your idea, your invention, into a potential successful product? Why is my product better than all the rest? Can you answer that question? you need to answer that question, because when you are confronted with the potential of licensing, you're going to have to answer a lot of questions dealing with how you came up with the original concept, the invention, how you developed it into a potential product, and why you think it's worth what it is, what you believe it's worth. Have you done the research, all of the research on the companies that are involved in that industry with products on the market? Especially look in details at the top 3 companies. Analyze their years in business, their executives, how long their executives have been in that position, and then consider, if my product is that good, what could it do to benefit the sales and profits of one of those 3 companies? Rather than go to company number 1 first, because they're already on the top, you look at the potential of company number 2, 3, or 4, and what would they pay to be number 1? And is your product good enough to justify their investment in making it a product? Remember, what you have is not a product. What you have is a technology. What you have is an invention. What you have is a, hopefully, patent. Once the product or invention is patented, and I mean a patent issued, and maybe additional patents filed, you now have some value. If a patent is pending, you do not own it. You have the rights to it up to the point that you can claim the patent is filed. But it's not yours until that patent is issued. And when you're dealing with a company for licensing of that IP, they're going to look at that value based on the fact, is the patent issued? When was it filed? How many examiners have been involved with telling you whether it's you can patent it or not patent it? How many claims are there, et cetera? So there's a potential that your product or your invention, let me go back to that, that your invention, your technology could be of great value to company number 2, 3, or 4. And I might add, based on personal experience, working with inventors now for well over 50 years, never, if you don't remember anything from my presentation, remember this: never do your own negotiating. And I say that with a deep understanding that I have been present when inventors who did their own negotiating lost the opportunities. So remember, you have a patent attorney, hopefully. You have advisors, you have an accountant, you have someone that knows your technology as well as you do, but also is a professional in knowing how to react again across the negotiation table. Very important. Next slide, please. And litigation. Despite COVID in 2020, there were 3,592 patent cases filed in the US district courts for litigation. And I say litigation, this is where someone has violated your patent. Now keep in mind again, litigation only comes about when you have found someone, a company, corporation, whatever the case may be, has violated your patent by virtue of the fact that they have created a similar product and put it on the market. I've been through several of these with one of my companies where it went to the federal courts and we won. We won the case against Walmart and many other big companies because they violated our patents, several patents. So suing is the last thing you ever want to do in any case. Believe me, that's why we have over 1 million attorneys. The average cost of a patent litigation is $3 million. So before you push that button to say, I've been violated, I'm going to go after those people who have stolen my idea, you better be prepared financially or have backing financially to enter into litigation. Okay? Next, please. Here's some wise words of advice. Do not fall in love with your idea or invention, because if it is successful, it's going to leave home, which is what you want. I have seen countless, hundreds, maybe thousands of inventors who have fallen in love with their ideas to the point where they have sacrificed. In one particular case I know personally, they have sacrificed their family, they lost their home, wife, children, and so forth. So remember, falling in love with your ideas is great up to a point. But if you take it to the extreme, be very careful because you could lose everything. And I mean, more important than the patent. How smart are you? Ask yourself that question. Can I do it on my own, or should I put together a team? In many cases, and especially my 50 plus years in Silicon Valley, I have seen almost 99% of all of the new ventures, especially the successful new ventures, with a team, not an individual. The individual can direct and run the team and manage the team, but it takes that team with all of the different qualifications, experience, knowledge, and so forth to show the value of that technology and that company. So here's a suggestion. Take a sheet of paper, an 8.5 by 11, and draw 2 lines down it, separating that page in 3 sections. On the first column, put strengths, your strengths. What do you really know? What are you good at? In the second column, put your weaknesses, and you have to admit it. What are you weak in? Is it legal? Is it accounting? Is it business? Is it pricing? Is it packaging? What are you weak in? List it in that second column. And the third column is to find someone with the ability, knowledge, and experience to match your weakness. You're going to create a team. You're going to create a strong team that when you sit down with funding sources, they're going to ask you the questions that you need to answer. And those answers will come from the strength of the team of people that you put together that, again, balance your weaknesses. You may be strong in the creation process. You may be strong in understanding, developing, and increasing the value of your technology. But it takes more than that to be a successful corporation based on new technologies. Okay? So what you do with that 8.5 by 11 sheet, once you've started filling it out, you paste it up or scotch tape it to your bathroom mirror. So every morning, or how often you go and look in the mirror, you're going to see that chart, and you're going to see, okay, whose name can I add to that third column today to balance out what is required and necessary to take my product to market. But remember, we're talking about licensing. We're talking about intellectual property. There's nothing to prevent you from going into the business, which is what I'm talking about, of producing the product and making more money than if you licensed it. Being in business for yourself with your own technology as a product on the market, you will earn more money than if you license it. However, the value of licensing in the world of IP is that someone else, probably a major corporation, with the resources necessary to not only further develop your technology, your product, package it, and put it on the market. They have the distribution and so on. So remember, there's no reason you can't go into business with your own product, technology. But the value of licensing is someone else does it for you using their resources and their funding. All right. I have here a website for Inventor's Digest. Any inventor that is on the viewing this presentation, if you're not familiar with Inventor's Digest, write down this website and check it out. They have a monthly magazine that is full of tremendous positive information on not only successful inventors, but areas where you can get information and resources to help you become successful, either successful in business, developing and creating a business, or in licensing. Check it out. And I might add right here too, this is a sore subject. There are scam organizations across the country that tell you they can get you a patent. They'll tell you they'll sell it. They'll tell you any kind of thing they have to tell you to get your money. Just remember, they're scams. The patent office itself has a list on their website of these organizations that either have been investigated or are being investigated by the Federal Trade Commission and other federal agencies. So when you hear the ad or broadcast on radio, there's a lot of it on radio, there's a lot of it in magazines. Be very careful. Do not send money to anybody that's asking you to pay for something that they're going to give you that is false. They're not going to do for you what you hope they will do just because you're going to pay them. Stay away from any organization. And if you don't believe them, or if you do believe them, ask them for credentials. Who have they worked with? Provide you with information on their clients. So be careful, okay? It's a crazy world out there. There's so many people that are taking advantage of inventors because inventors are gullible. Inventors are those very positive souls who who in most cases believe in everything. They're creative people that actually are building the world of tomorrow, because there are successful inventors and there are not so successful inventors. And there are those who in their garage are tinkering with putting together something that, well, now, why didn't somebody think of this before? And in most cases, someone has. And as I said earlier, just because it isn't on the shelves in Walmart or any other major store does not mean it has not been invented and produced, or just invented. Start with the patent office files, check to see if anything in that category similar to what you're working on is available or has been patented. But that's not the end answer. Look beyond the patent office and investigate the whole internet. In the old days when I was lecturing to students and others, it was always go to the librarian in a major library and ask the question. And she or he will take you down these long, dark aisles. They hand you a book with the answers. Today, you have but a button to push. The internet has made it so simple for you to do your own research and find the resources you need to answer the questions that you have. It's all out there. How about the next slide, please? All right, wait a minute. Okay, I'm getting ahead of myself. How do you know it will bring you fame and fortune? I had one inventor at one time tell me, well, I showed it to my next door neighbor, and he said, if that was on the market, I'd buy one. Then I showed it to my grandmother and asked her if she would invest in it. She said, certainly, it's a terrific idea. That is not research, and that is not the resources you want to explore. As I said, the resources and research are a click away. And one other point of information, do not borrow money from relatives. No matter how good you think it is, I have seen situations where the inventor, who is either maybe a son-in-law or whatever the relative relation is, has been ostracized from the family because he or she lost grandma's investment. I might add right here too, if you follow anything that's going on in the world of finance, investment, and so forth, especially out of Silicon Valley, you will see billions and billions of dollars being invested in new technologies, new companies, and the money's there. Being able to reach that money is another question. You start with people you know and ask questions. Do you know anyone that would be interested in investing in this? And it's the money is out there, as I say again, just be careful whose money you're taking. And before you reach in your own pocket to pay an attorney or a designer or a scam organization, the money you are reaching for belongs to the family, your wife, your spouse, your kids, their education. I keep emphasizing protection. be extremely careful how you spend money on your idea. Okay, next slide, please. In summation, the human mind is creative. History has shown the results of creativity. All you got to do is look around yourself. I mean, look around your own room, look around your car, look around your neighborhood. Everything you're looking at is the result of a creative idea. I mean, just because Edison came up with the electric light bulb or electricity does not mean that that's an end to it. There's no limitation to what you can create mentally and physically in this world today. A great many of the new successful inventions, products, technologies are being built upon what already exists. Now, grant you, if it's patented, you can't do anything about it unless you get a license from that individual or company that owns that patent, which is also possible. But it was our founding fathers 250 years ago that came up with the concept, you know, how do we stimulate creativity in America, in this new nation? Let's create a system where the individual that comes up with something new can at least file for protection on it to where they themselves could become wealthy with it, or at least earn money for it, with it. So remember that we are, as a nation, we are an unlimited powerhouse of invention and innovation. We've proven it. We keep proving it almost every day. Look at the auto industry. What's happened with it? Battery cars on the highway, autonomous cars. Pretty soon you'll be able to sit back and not even drive and tell the car where to go, and that's where it's going to go. I don't know how safe it's going to be, but so my hope is that I've briefly educated you on the IP world, but also provided some inspiration. Go turn your dreams into reality. Remember, it's unlimited what you can do. You have a brilliant mind. I don't care what situation you're in, whether you're a university professor, whether you're digging ditches, whatever it is you do, you're creative. You can come up with a better way of doing something that is already being done. I have put my email on this slide, and I welcome anyone who is interested in advice, suggestions, contacts, whatever. Send me an email and ask me the question. Here's my problem. I get it all the time. I deal with students at UC Berkeley, UC Davis, New Mexico Tech, and so forth. On here's my problem. Well, problems are not only solutions, they're opportunities. The world is full of opportunities. And you as an individual has the ability to solve problems which turn into opportunity, which turns into potential income, and in some cases, fame, like the 4 people I told you about. I mean, when Barbara Carey came up with Harigami, she knew it was going to be successful. And in turn, she has come up with additional products since then that have made her richer yet. So if we can have the last slide, I want to tell you about October 14th. For the last 4 years, well, except 2020, I have created the Inventors and Entrepreneurs Workshop on the campus of New Mexico Tech. In those years, we averaged about 175 people for 2 days. Business people, inventors, entrepreneurs, all areas of our world, looking for help, looking for advice, looking to meet other people, looking to meet the speakers. On this coming year, well, it's not a coming year, we're here already. October 14th, 2021 will be the 5th annual Inventors and Entrepreneurs Workshop. It's a 1-day event, it's not 2 days, but the speakers and the presenters will provide you with not only tremendous amount of information that you can take with you, but the SBA, Small Business Administration, will be there. Of course, I'm looking at my own notes here. The patent office. The patent office will have a booth, and the SBDC will be there. There'll be a lot of people offering advice, speaking, and attempting to help make you successful in what it is you're doing or what it is you're dreaming. Just keep dreaming, but turn those dreams into reality and turn that reality into success to where you can either start a business that employs people or at least license that IP out to companies that will grow and employ people and help the future of America's economy. I got a lot more I could say, but I'm running out of time. So, questions?
We do not have a question right now, and I know Steffi's anxious. She's wanting to say something, but we do have a comment from Kate. This was absolutely marvelous. Thank you to everyone involved in this superb day. Excellent presentations by such knowledgeable professionals. And of course, special thanks to Larry Udell for wisdom illustrated by stories of great inventors he has known. Wonderful. Steffi, do you have
No,
thoughts?
I want to second that. That was very good. I enjoyed listening to all the stories and all the advice. I think that's very good. Does anybody else have comments? We still have some people out there in the.
We still have a couple minutes left, and I do not see anything. I think it was oh, we have someone that's raised his hand. I can allow him to unmute. Oh, I think it's Paola. Okay, hold on. Here we go.
I'm sorry, I did not intend to do anything, but given the opportunity, I wanted to agree with the comments. That was a very informative talk by Larry. I actually learned a lot. It was really interesting. So thank you so much.
Thank you.
You're welcome.
Awesome. I think this was a great day, Steffi. I think we had a lot of valuable information come through. Do you have any last words of wisdom for our attendees today?
Well, I think that we had a very good World Intellectual Property Day. We went from the very basics to the very extreme on cybersecurity and then on licensing, and that was very good advice. I do want to thank all my presenters, Usama, Paola, and Larry. These guys are still on the line, so that has been very good. We will have a survey, and so we would want any kind of feedback from everybody that attended and presented. Once again, thank you. And now we all know about World Intellectual Property Day on April 26th. So that's a good thing. Do you have anything else to say, Larry? Isama?
No, I just wish everyone well, both physically, mentally, and otherwise. I think we've lived through a horrendous personal year, each of us, all of us, but we've got a future to look to. And I think, again, creativity is what came up with the results to help alleviate COVID and maybe eliminate COVID. I mean, if you look at the short period of time that Pfizer and others took to develop a technology, a serum, or whatever the case may be, in that period of time is unheard of in our history.
Yes, and they were able to take advantage of what they had learned before and what had been done before. And so, and they expanded and were able to solve world problems. So that's the way it works.
Another example of being challenged.
Stepped up.
Well, that's all our time for today. I'm going to stop the recording and